Yes. My lord, this is a fair price shop. 8 months back, my shop has been suspended. No action is taken. It may be listed tomorrow morning.
Tomorrow for motion?
For orders.
Orders, no. Why?
Because
Tomorrow, no.
they are doing nothing.
We'll
Let-
see whenever it is.
Let it be
When
7
did you
on.
file the petition?
Let it be on 7.
Huh?
On 7.
7 of October. We'll have it. When did you file the petition?
No, it was filed, my lord, on 14/2/25.
Hello? We'll have it on Monday.
Monday.
May I please, Lordship, for listing for motion. My lord, matter released for my lord tender and site visit certificate had not been countersigned by the executive
Tomorrow?
tomorrow, Lordship.
May it please the Lordship. My lord, may it please the Lordship. My lord, I pray to my lord, I pray for posting of an application for recalling an order passed by my lords. My lord, in a writ petition. My lord, we have filed it yesterday, my lord. Any date convenient to your lordship tomorrow if it is
Monday.
my lord.
Monday.
Monday, my lord. I'm obliged, my lord.
Supplementary item 20 for motion.
Yes, what is this?
The matter regarding settlement of market matter.
Hmm.
The petitioner before lordship, my lord, they submitted tenders, my lord, for settlement of Shantijan biweekly market and Balishatra biweekly market for the year 2025-26.
Where is PNRD?
PNRD.
What happened?
My lord,
You are the highest.
no, my lord, the tender box was opened, but the company's statement has not been prepared.
You are the highest.
We are, my lord, intended to highest, maybe highest, but because since the combative statement has not been finalized, our grievance is that, my lord, settlement was to be, my lord, finalized within stipulated time.
And they issued a new fresh tender.
Not issued fresh tender, but they are going to, my lord, manage the market by the, my lord, authority by constituting a committee. It is my case, my lord, paragraph 13, page 10. Paragraph 13, page 10 below, that the petitioner begs stated that despite the apposite facts and circumstances of this case, the respondent authority has not finalized the settlement process of the apposite market till date. The petitioners on inquiry came to learn from the office of the Nava Jila Parishad that the Jila Parishad is going to constitute committees by the officers of the concerned Anchalik Panchayats and some vested interest persons to manage and run the apposite markets department. It is our grievance. The market ought to be settled within a stable time period.
Where?
Paragraph 10, paragraph 13, page 10.
That after the CEO in my notices were all concerned at the many. You are Mr. Hawk. Mukul Hussain.
Mukul Hussain and two others.
You got a less 59 lakhs.
Yes,
Oh.
my lord, it was for Shantijan biweekly market. Petition number 1, petition number 2 and 3, they submitted tender for settlement of Balishatra biweekly market.
So why 105.5 would not apply?
Yes, it applied, my lord. But since my lord, that has not been arised, my lord, because my lord,
No, your case is that now they are going to take up the steps on the 105.5, although they have a proper bidder.
yes, my lord. And the secondly, my lord, since my lord, regarding Shantijan biweekly market, 6 bidders, my lord, submitted tenders. And in my lord, Balishatra market, my lord, 5 tenders have been submitted. So my lord, that maybe not be arose.
Why you are mentioning about the other two markets? How many petitioners are here?
Three petitioners, my lord. Two
All
markets.
three petitioners have submitted differently.
Yes,
Why
sir.
one writ petition?
Because my lord, same NIT, my lord.
What? One? You cannot file one writ petition
Yes,
for
sir.
everybody. Choose one of them.
My lord, same NIT, same NIT, same, my lord. date.
Choose one of them. Whom do you like more? 1, 2, and 3. You
But,
cannot have
uh,
three tenders. Three tenderers have submitted pursuant to a tender notice for different markets in one petition. My goodness.
My only grievance, my lord, since my lord, that tender.
Which of the one do you want or you like or given you better material considerations?
that,
1, 2, 3. Who?
my lord, since my lord, our grievance is that they have to, my lord, settle the market to anybody with highest bidder bid.
No, no,
Hmm.
no. You
The-
cannot come up with this. Everybody has quoted for different tender.
Yes, yes.
I'm not going to allow these type of writ petitions. Subject to payment of 20,000 each to the DLSA.
My lord.
Which one?
Since my lord, NIT was my lord.
20,000 each.
No, no, my lord. It is very high, my lord.
Pay
Then I-
something to the DLSA. Do something good for the people.
If
This
it is
can't
my-
happen. Three bidders
Two
for
markets.
different tender for different markets all joined together. It's a cartel.
Since my lord, only for settlement of my lord, as per NIT, so my lord,
Understood why the three bidders have come together.
two markets, my lord. Two
Three markets.
Two markets.
Two markets.
Yes, my lord. Shantijan Baigli market and Balashatra Baigli market.
So Balisatra, one person has also come who is quoted lesser than it, the number 2.
Yes, my lord.
Number 2 has quoted more than number 3.
Number 3. But
So are they not conflicting?
my lord.
Normally the highest bidder gets.
Yes, my lord. But
So 2's
Ah.
consideration is conflicting with 3
But-
if it is in respect to the same bidder.
our only grievance, my lord, they have to finalize the settlement process, my lord. So, my lord, we are not, my lord, disputing between us, my lord. As per the NIT, my lord, they have
Not
to.
satisfied. This type of cases not satisfied. I can issue a notice returnable by 6 weeks without fixing a date. Nothing
Otherwise,
will
that I will do the.
and it
give you a lot of
never list,
consider,
get
my lord, I
listed.
will do, my lord, with liberty to file a fresh separate petition.
Better.
So that,
Or you can do one thing. Let me issue notice for 1.
Hmm.
As regard 2 and 3, you take the liberty to file afresh. Something is done.
yeah, yes.
Better.
Then, yes, ma'am.
1 is there, 2 and 3 you will file separately.
Yes. Ma'am. Then 2 and 3 maybe will have to.
Yes,
Step.
liberty I'm giving. And more particularly 2 and 3 are conflicting. They are at loggerheads. The moment you are filing together 2 and 3
Yes, I
means
understand,
they have formed a cartel
my lord. Since, my lord,
to
on
get
our,
that weekly market.
our prayer only to finalize the settlement process. So, my lord, we are not disputing ourselves between us.
I hope you are understanding what I'm
Yes, ma'am.
saying. 2 and 3 are for one market.
Market, yes.
2 has quoted 84.
And only 83.
3 has quoted 83.
Yes.
Both of you, if there is a cartelization,
Hmm.
on that basis your tender would be rejected. Are you aware of that?
Yes, my lord.
Issue notice. You are
For the PNRD Lordship, respondents.
PNRD.
Lordship.
Okay. Issue notice making it returnable on 22nd of August 2025. 22nd. Oh, 22nd is too long. Have it on 18th. 18th of August 2025. Full stop. Mr. So-and-so accepts notice on behalf of the respondent numbers 1 to 4. 1 to which one?
Lordship.
Executive officer?
All
No, no, no.
Oh, yes, my lord. It is, my lord, 3, not 4.
1, 2, and 3.
3.
Yes.
Full stop. At the outset, the Mr. D. A. Kayam, extra copies of the writ petition be served upon him during the course of the day. At the outset, Mr. D. A. Kayam, the learned counsel appearing on behalf of the petitioner, submits that as regards the case of the petitioner number 2 and 3, he would not press the instant petition. taking into account that their cause of action is different from that of the petitioner number 1. He therefore submitted that the names of the respondent petitioner number 2 and 3 be deleted. Full stop. Further to that, he also submitted that the Dhing Anchalik Panchayat, the executive officer of the Dhing Anchalik Panchayat would have no say, taking into account the present dispute in as much as the petitioner number 1 has no grievance as regards the respondent number 4. He therefore submits that the name of the respondent number 4 may be deleted. Taking into account the above, the names of the petitioner number 2 and 3, as well as the respondent number 4 are struck off. Full stop. The counsel appearing on behalf of the petitioner is directed to file a fresh memo of parties before the registry of this court within 2 days from today. Full stop. The registry of the court on the basis thereof basis of the present order as well as the fresh memo of parties shall make necessary correction in the cause title and also update the same in the CIS. Full stop. This court further grants the liberty to the petitioner number 2 and 3 to file a separate writ petition, if so advised. Next. The case of the petitioner herein is that on 7/6/2025, a notice inviting tender was issued for settlement of different markets, including Santijan bi-weekly market. Full stop. The petitioner number 1 participated in the said tender process, and it is his, and he has reasons to believe from after the opening of the tender documents that the petitioner is the highest bidder. Be that as it may, the respondent authorities, for reasons best known, have not settled the tender with the petitioner. Rather, the petitioner apprehends that in order to deprive the petitioner, the respondent authorities would take steps for running the said market by constituting a committee of officers of the concerned Anchalik Panchayat. He therefore submitted, the learned counsel for the petitioner therefore submitted that in terms with section 105, of the Assam Panchayat Act as amended up to date, the respondents authorities, if they have a valid tender bidder, it is incumbent upon the respondent authorities to settle the tender rather than initiating process under section 105(5) of the Panchayat Act. Full stop. The counsel appearing on behalf of the PNRD shall obtain instructions on the next date, positively on the next date, as to why the settlement proceedings, the tender process have not yet been processed till date, and as to whether there is any move on the part of the respondent authorities to form a committee of officers of the concerned Anchalik Panchayat, list accordingly.
Lordship, given the dates,
18/8/2000.
August.
21.
Yes, Mr. Monique.
May it please your lordship. Madam, in response to a tender for procurement of high-end desktop computers, we had participated,
Your technical bit cancelled.
rejected on grounds at page 53.
Page
53.
53.
53.
Yeah,
May I read?
not technically
The firm
because
is
the
not technically
documentary
qualified.
evidence of the bidder's last 10 years experience of supplying desktop, workstation, laptop not complied. Complied? comply. Firm was blacklisted by IIT OEM past 10 years business in India, not complied.
If my lords have page 8 for the moment of the writ petition, we have pleaded where what we have annexed to tender papers.
Page
8.
8,
7 would be better. 7 to the last.
7 to
Paragraph 9.
Hmm.
On the count of the petitioner not having complied, documented evidence of last 10 years experience of supplying desktop computer workstation laptop, we say A and B, which my lord finds at page 54 and 57. A, the petitioner had submitted the valid trade license indicating nature of the business. B, the petitioner had submitted a detailed company profile showing the track record of business operations in the domain of IT hardware supply for over 10 years. 54 and 57, those are there.
Now let us see the clause.
My lord, that clause lordship finds at page 28. That is additional documents which were required to be furnished in response to clause 10.
Should be in the business of supplying desktop computer workfare for the last 10 years in India.
My lord,
Now, this is okay, but what are the documents you are required to
My lord.
submit?
we have given in page 53, 54 and 57. 54,
No, what are the bid documents you are required to submit?
these are documents, my lord.
No. Give it, processor, operating system, special terms.
Rest everything cleared. Only on these 3 counts they are
Now,
having.
how does the bid, how is the bid document, what are the
Annexure
documents
B at page
required from the
28.
seller? Experience certificate, past performance, bidder turnover certificate requested in ETC OEM authorization certificate, annual turnover, so and so in case any bidder is seeking exemption under experience, the supporting documents. So these are the documents which you are required.
Lordship,
Annexure A, page 15,
my lord.
isn't it?
And lordship takes page 28. This is in response to clause 10 at page 24.
Yes.
Clause 10 at page 24, it says buyer uploaded etc document, click here to view the file. Once we click, we come to page 28. These are the
Page 24.
24 would correlate to 28. 24 clause 10.
Your ATC documents.
Yes.
Here.
Now, when we click here, we come to 28.
Uh.
28 would say the bidder should be a private public company limited registered under Companies Act. This is done. Bidder should be in the business of supplying desktop computer workstation laptop in bold for the last 10 years in India. This we have said 54, 57, we have met. They say we have not met. We said we have supplied documents to substantiate this document. Next, GST, PAN, all done. Next, bidder must submit a declaration confirming that the bidder has never been blacklisted in any government institute, organization, or PSU. On this
declaration.
My lordship. On this context, we have submitted the declaration that presently not blacklisted, and we have submitted an order passed by this honorable court between the same parties, albeit in an earlier tender process, where on the score of blacklisting, it was rejected, and this honorable court had that it cannot be forever between the same parties.
Show me that.
My lordships, that lordship would find that page 64.
Page?
64. It's almost an action in contempt. Page 64.
Yes.
For a moment at page 64, the parties, it's us, Eastern Technology Group, versus the same parties which are in the parties of the writ petition here in Milord. The tender is also the same, page 65, paragraph 2, the first line. The petitioner's case is that the petitioner participated in a tender process pertaining to bid number so-and-so, 28/8/24, for procurement of desktop computers Q2, so-and-so. The same thing happened. If my lord turns to page 66, paragraph 7.
When were you blacklisted?
2012. Page 7, paragraph 7, page 66.
So if it is 2012, then you have to take 5 years.
No, come on. We have crossed that. We are also in the business with IIT also.
No. 2012.
My lord.
You see, in the earlier
Here.
case by the Supreme Court, so it was blacklisted in 2013.
12 for 3 years. 12 for 3 years.
Kindly come to page 66, paragraph 7.
I am there. The issue here is whether the petitioner's bid could have been rejected on the ground that he had been blacklisted in the year 2012 for a period of 3 years, which effect had subsequently been over by the year 2015. The answer to that is in the negative. Further, the reasons for which the petitioner's bid has been rejected, that is on the ground on which he had been blacklisted earlier, amounts to deciding that the blacklisting of the petitioner in the year 2012 could have been considered to be in perpetuity. In the case of so-and-so, which was disposed of on 16/8/22, the Supreme Court had held that one cannot be blacklisted for life. The order of blacklisting, to the extent that it has not specified the period, cannot be sustained. Since the order of blacklisting was passed back in 13 and the writ petition was dismissed in 18, that was in that case context, my lord, before the apex court. The Supreme Court deemed it appropriate to exercise its powers under Article 142 of the Constitution to pass an order of blacklisting the appellant for a period of 5 years from the date of the order passed. The above clearly shows that there cannot be an order of blacklisting for life. The above being said, the petitioner had not been blacklisted for life, but had only been blacklisted for 3 years, which was over in the year 2015. Consequently, the respondents could not have rejected the petitioner's bid by acting as if blacklisting order of 12 would have its existence beyond 3 years in perpetuity. In view of the reasons above, the rejection of the petitioner's technical bid by the respondents hereby set aside, as the counsel for the respondent number 2 has submitted that the contract has been awarded to the tender whose bid was L1. The court is of the view that the present writ petition would be relevant for
So
future
your
tenders.
blacklisting will be valid from 2012, 13,
15,
13, 14
14 to 15.
and 14, 15.
True.
And now we are concerned as to whether for the last 10 years you have been blacklisted.
This, so far as blacklisting is concerned, it says true, correct. What I am on between the same parties in respect of a same or similar, if I may rephrase my lord, similar supply of desktop computers, when a judicial pronouncement is there on the aspect of blacklisting, so far as we are concerned, on the same touchstone, that it would be relevant for future tenders. Whatever the observation is, this
But
having
the term of the tender says 10 years. Whether you have been blacklisted for the last 10 years.
operational, I would refer to page 15 one second, page
Let us-
24 one second,
Let us see page 54,
24,
24, 28.
28, I'm sorry.
The bidder must submit confirming the bidder was never blacklisted in any government so and so.
For the last 10 years.
This was never blacklisted.
Yes. So this is
There is no 10-year business.
10 years for this experience purpose,
Okay.
OEM otherwise.
Mm.
This is never blacklisted. We say, regardless of the pronouncement by this honorable court, no blacklisting can be in perpetuity. The rigors of that blacklisting would be during the operational period of blacklisting and no more, notwithstanding the stigma it carries forward. Now that would be a different debate altogether. But so far as this petition is concerned, on between the same parties, a decision, a judicial pronouncement is there. This was communicated to them. They chose to jump over it and willfully and deliberately not.
Here the ground is the firm was blacklisted by IIT OEM past 10 years business in India, not compiled.
No, this is two parts. There are two parts.
Hmm.
What my lord is on is a third part. IIT Guwahati is one, and OEM past 10 years business in India not complied.
No, I am not saying for myself. This is what is there in
No,
page
there's a full stop.
53.
There's a comma, a separator, my lord. They probably not properly
Where is
punctuated.
the comma?
The firm was not blacklisted by IIT Guwahati, comma, and we take original equipment manufacturer, past 10 years business in India not
So
complied.
your therefore thing is, you were technically competent in respect to the supply made for the last 10 years.
Right.
Secondly, even if there is a clause that I was blacklisted,
Lordship.
but the blacklisting cannot be a consideration taking into account that this court
My lord,
had observed in another judgment
my lord.
that your blacklisted ended in 2015 and when the period is 2015, thereafter it cannot continue
My
or
lord.
debar you from participation.
Moreover, between the same parties on the same issue, nature of tender. It's not that a third party is coming in now.
It cannot be the same issue because
No.
the tender is different.
Tender is different. The issue of the
Whether the
procurement-
same term was there earlier, no.
verbatim, I need to check, but on the aspect of this.
If you check, then the matter gets adjourned.
No,
You need an interim.
Today, my lord, they
You need an
proceed-
interim.
Lordship.
So
Third one-
would you like to again go back and look into it or rather
That is
ask for an interim?
That's it.
Fantastic.
And the third term, page 68. Third one, Milo also made.
And nobody is appearing for the
We have
government.
served the copies to the SCNIT, Milo.
Oh, they don't appear. It's okay. National Institute of Technology, Silchar. Government of Assam, National Technology, Silchar. Okay.
Yeah.
And who are the other 4 and 5
4 and 5 are those two persons
who have been?
who had supplied the Acer and of the same number, but theirs was accepted, ours was not.
So they are technically qualified.
Technically qualified, yes.
So you have done it as per FCON,
Gotcha.
4 and 5.
4 and 5. To just keep that thing in the
So there is nothing by which I can
So we tried.
debar you from getting an interim. Issue notice making it returnable on third of September.
Lordship.
3rd of September. No, 3rd of September, it will be too long. Have it on 20,
Lordship.
28th of August. Issue notice making it returnable on 28, 2028. None has appeared on behalf of the respondent numbers 1, 2, and 3, in spite of the fact that notice have been served upon in the office of the Deputy SGI, Guwahati High Court. Full-stop. Be that as it may, this court permits the counsel for the petitioner to effect service upon Mr. R.K. Dev Chaudhary, the learned Deputy SGI, during the course of the day, insofar as the respondent numbers 1, 2, and 3. As regards the respondent number 4 and 5, the petitioner is directed to take steps by way of dusty, routed to the registry of this court, and file an affidavit of service on or before the next date. The case of the petitioner, in brief, is that on 12/6/2025, the respondent number, who has issued? 2. The respondent number 2.
United.
Respondent number 2 had floated a tender for supply of high-end desktop computers. The bid document, which have been enclosed as Annexure A, reveals what are the documents which are required to be supplied by the seller. Clause 10 of the bid document further stipulates that the buyer has to upload ATC documents. These documents have been mentioned in Annexure B to the writ petition. From a perusal of the said document, it is seen that the bidder is required to be in business of supplying desktop computer / workstation / laptop for the last 10 years in India. The petition, the bidder also has to submit a declaration confirming that the bidder had never been blacklisted in any government institute, organization, or PSU. The petitioner, in pursuance to the same tender, along with two others, no?
I have submitted. I have submitted.
Along with two others,
So many.
along with various tender bidders, submitted their respective bids,
38, along with 38 others.
along with 38 others, submitted their respective bids. It is the contention of the petitioner that the respondent, number 2 and 3, had rejected the bids, the technical bids of the various bidders, including the petitioner, except the respondent number 4 and 5. Isn't it?
Lordship.
Except the respondent number 4 and 5. The petitioner is aggrieved by the rejection of the technical bid on the ground that the petitioner, on two grounds. That is, that the petitioner firm did not provide documentary evidence of last 10 years experience of supplying desktop, computer, workstation, laptop. And the second reason being that the petitioner firm was blacklisted by the IITG.
There's a third also.
What?
At page 53, OEM past 10 years business is India not complied. We have met it at page 68.
Second reason is this. And the third reason being that the OEM past 10 years business in India was not complied. Mr. S. Punik, the learned counsel appearing on behalf of the petitioner, submitted that insofar as non-submission of documents relating to last 10 years experience of supplying desktop, computer, workstation, laptop, the petitioner had submitted a valid trade license indicating the nature of the work, and further, the petitioner had submitted a detailed company profile showing the track record and the business operations in the domain of IT hardware supply for over 10 years. In respect to the reason pertaining to blacklisting, the learned counsel appearing on behalf of the petitioner submitted that the petitioner had duly submitted a formal declaration. Further to that, he stated that though it is true that the petitioner was blacklisted by the IITG in the year 2012, but that was only for a period of 3 years. And in 2015, the said blacklisting was over. This aspect of the matter have further been clarified by the learned coordinate bench of the court in an order dated 16/12/2024 in WPC number 6724/2024, which was a proceedings between the petitioner and the respondent numbers 2 and 3. Insofar as the reason pertaining to the OM should have been in business for the last 10 years in India, the learned counsel submitted that the petitioner submitted the certificate of incorporation of Acer India, which clearly shows the Acer's presence in the Indian market for over 10 years. The learned counsel therefore submitted that the reasons for rejection of the technical bid of the petitioner was not reasonable. Rather, it was irrational and arbitrary. The learned counsel further submitted that in respect to the respondent number 2 and 3, this is the second round where the petitioner has to come before this court in respect to the blacklisting, which issue have already been settled by this court. He therefore submitted that the respondent number 2 and 3 cannot act in a being a state cannot act in a manner which would violate the mandate of Article 14 of the Constitution. This court have duly perused the bid document as well as the enclosure thereto. In addition to that, this court have also perused the documents which have been submitted by the petitioner. And further taking into account the submissions so made by the learned counsel for the petitioner. This court prima facie is of the opinion that the petitioner has a case which requires consideration. This court further is of the opinion that in the circumstance, the tender process is permitted to proceed. It would lead to multiplicity of proceedings. Accordingly, this court states the further proceedings, further states the tender process
Page 12.
in tender process initiated by the respondent number 2, more particularly in connection with the bid number GEM/B/B/6337786 dated 12/6/2025 till the next date.
Wait. But I'm told Mr. S.P. Chaudhary was appearing for respondent numbers 2 and 3.
But you served it on somebody else.
No. We've served it on his clerk, one to the
You
union.
served it to Mr. S.P. Chaudhary or whom?
S.P. Chaudhary's clerk for 2 and 3.
You are there.
No. We had it served.
You served it to Mr. S.P. Chaudhary or not earlier?
Yes. Through his clerk, through our clerk. It was served.
Oh.
For 2 and 3.
To report Mr.
2 and 3
Chaudhary,
would go to him.
been served upon the rear. It gives the liberty to the petitioner report to serve copy upon Mr. Arkadev Chaudhary in respect to the respondent number 1 and to Mr. S.P. Chaudhary for the respondent number 2 and 3.
For admission item 2.
When the petitioner was appointed 2014 as a casual employee, my lord, till April 2025, his salary was drawn out. And my lord, in affidavit filed by the respondent number 5, paragraph 6, they have mentioned clearly that his service was warranted. And accordingly, my lord, this pay and slip for the month of May was also prepared. But it was objected by the Treasury Office on the ground that no financial approval given. My lord, while this query was made, the finance department made a statement on last occasion that they prepared the consolidated statement, but they do not know whether this person is included there or not. My lord, Upendra's case is very much clear on that point, my lord. And it is nobody's case that his service was not warranted. Paragraph 6 of their affidavit. Still, in the same institution, other 2 casual employees are working and they are also getting their the monthly remuneration except me.
Mr. You are a graduate?
My lord,
Are you a graduate?
my lord, no, I am not graduate. The sole question is that, my lord, they do not, my lord, expose any reason, my lord, why, my lord, my salary has been stalled, my
The reason is clear at page 53 and 54.
my lord.
It is apparent. Page 53 and 54. The finance has not given the approval.
My lord, finance has not made approval, my lord, for this
The
purpose.
problem is how will they pay?
My lord, kindly see, my lord, for the, my lord, current session, my lord, up to April 2025, my remuneration has been cleared. But from the month of May, my lord, in current session, my lord, what is the reason, my lord, suppose the approval not given, but two other employees has been given approval, my lord, who are working in the same institution, my lord. Kindly see.
Understood. But the question is the finance has not done it. It is not the fault of that officer.
My lord, understood, my lord. I'm not saying that it is the fault of that respondent.
No, why the finance has not been given?
Yes.
That is the question which will be
Yes,
taken.
absolutely, my lord.
Now the question is whether there is a need for your services.
Exactly, my lord.
The finance may have,
Yes.
must be knowing better.
Yes, my lord, that is the
That
ultimate.
there is no need for any casual
the-
employees
For
out there.
the present reason, my lord.
What work are you doing?
My lord, I'm a peon there.
Sure.
No, even finance is nowhere says, my lord, that approval is not big. It is just a statement on the part of that respondent of fine saying that the treasury official informed that no prior financial approval is given. Oh, my lord.
Kindly come to page 53.
My lord.
Why you are saying that, submit?
For 53.
With reference to this, I would like to inform you that the monthly wages for the employee, namely so-and-so, casual driver so-and-so, were prepared and submitted to Al Gwalpar for payment. However, the bills were returned by the treasury officer citing an objection based on OM number dated so-and-so, wherein it is mentioned that the DTOs are not authorized to engage casual employees on wage basis without prior approval from the finance department. It is pertinent to mention hearing that a note sheet had earlier been placed before the then members so-and-so seeking necessary order regarding the same OM number so-and-so. Despite the said restriction for the sake of smooth functioning of this tribunal, the then MACT has extended the period service of the three numbers of wage employees including so-and-so for another 3 months by an order, which was subsequently extended until further orders by an order dated so-and-so. Following correspondence with the concerned department, we submitted the bills to so-and-so, along with copies of the so-and-so by the Honorable High Court, as well as the order dated so-and-so, passed in so-and-so by the High Court. Consequently, on the strength of the said note and the order of the High Court, the treasury passed the bill for the said two employees. However, the concerned officer has objected and refused to pay the bill for Keshav Kolte as there is no prior financial approval from the finance department authorizing to engage in casual employees on the wage basis. This is the reason.
Well, no doubt, my lord, it shows that because of my lord finance approval, my lord, but my lord, kindly see that till my lord April 2025, there is no any objection from the part of my lord finance department or that respondent of file. Now afterward, my lord, suppose finance department not given the approval, my lord. They have to show the reason.
Has the finance department given the approval?
No, my lord, it shows, my lord, no approval was given. That is clear, my lord, and there is no doubt to that. But question is that, my lord, the open das case, case 2017 make it very much clear that casual employee cannot be sacked, my lord, till their superannuation, my lord.
Huh?
Open das case 2017 make it very much clear.
Which case?
Open das case 2017, my lord.
Upendas is a different case. You say that is a consented order.
Yes, my lord, concept,
That
but
has no
ultimately it
relevance
also
here.
covers my case, my lord. Can you say?
Upendas case has two aspects.
Right.
First, the concept, the request for regularization was rejected.
Yes, my lord.
Second, payment exactly as the lowest rung of the year was also rejected.
My lord.
What was given was taking into account the submissions so made by the finance department.
Right.
I think most probably the Advocate General or the Additional Advocate
Yes.
General then, a submission was made that we are going to accommodate those persons who are working till 10 years from
10 years.
2005 or 7 or something. 10 years for that, we are going to accommodate.
My lord.
This is a one time.
Yes.
This is the problem which is being faced. It is a one time.
Right.
They cannot be beyond that because the problem which is arising is thereafter there was there were various steps being taken by the finance department along with those particular department to chalk out those persons who were having 10 years
Yes.
and thereafter they were regularized giving the lowest of the minimum. Yeah, this was being done. So how is Upendas
But
coming into
even
the
on
picture here?
The strength of that order, even after, my lord, that this process of, my lord, keeping of the persons in job was, my lord, approved by this honorable court, my lord, in 2018 also, my lord.
Whose?
This honorable court, my lord, similar situated person, Lordship, kindly see for a moment. This judgment. On the strength of the Upendas case, my lord, the similar situated person who sacked, my lord, for the moment of, my lord,
Do you have this 10 years prior to that period as per Upendas?
no, prior to that, no.
Then why are you making that submission? And if somebody has done it, that is wrong. That is a wrong reading of Upendas.
Hello.
Upendas makes it very clear to the effect.
My lord,
You don't make those type of submissions. It is not going to help you out.
my lord.
The only thing which can be help you out, yes, Mr. Gogoi, what is to be done here?
Go now, please say what.
First of all, the question is whether the requirement is there for these employees
Yes,
as casual employees.
my lord, that, my lord, they will have to justify.
So they say that it is required.
But my lord,
Then why you are not doing it?
then my lord, the proposal.
You are not going to give them a huge pay. You are only going to give a particular payment to be there.
My lord. Well, if the requirement is there, my lord, they will have to submit a proposal justifying the same, not in the budget, but a separate proposal. That, my lord, this person is required for so and so, and this is the, my lord, budgetary allocation for this particular petitioner. 9,000, my lord, it will be 101 lakh 9,000 or something. I've already talked with them. In that case, they can definitely consider. But, my lord, in the budget, they will
But
show, my lord.
let this be done. Let this proposal be submitted by you
Yes.
for the case of the petitioner
Right.
for this financial year. But this would not create any right upon him thereafter or this financial year or till a particular period. Because the earlier you do,
My lord.
because you see he's working.
My
So
lord.
some payment has to be made.
Yes.
But if the problem is in a very catch-22 situation, this court either has to give up, say that he is no longer required. This is not for this court to decide to that
Got you.
effect.
My lord.
Now, you have to tell him that, look here, this is the notice we are giving you. We are not going to give it. Now, the question is whether you require his service is a very important thing. There are two aspects. First, whether you require his service. Secondly, for that, you have to give a justification.
Fine.
The finance will consider to that effect
Got
as to whether this service is required for this particular year. But for the period for which he has worked, for that period, he has to get something.
Right.
He has to get his salary. So if you can do it as early as possible,
Yes.
then the finance can give that approval from their budget or whatever may be, and then close the chapter.
Ex post facto, we can give it. my
Ex
lord.
post facto can be given, and then it can be closed the chapter. As regards the petitioner's request for regularization, I'm rejecting it. There is nothing done. But I'll keep the matter pending only to that effect, and I want this thing to be done early, taking into account the delay. If there is a delay, the petitioners have to be kept. still it is being null.
And my lord, one more thing, my lord, if that particular person is required as a peon, my lord, that post is required, then they can submit additional proposal for creation of a post and to fill it
Mr. Gogoi,
regularly.
you also know, I also know what happens.
No, even
The High Court, the administrative side has been asking you for 200 posts. You say by 2026 you are going to give 100 posts. This is the state of affairs, and now you are saying the creation of it.
no, my lord.
You also know how it works.
No, not for the petitioner. It will have to be filled up by regular selection, my lord. That's what I'm saying. Not for the petitioner. It will have to be filled up by regular selection.
That obviously, that has to
Because
be
that-
therefore I'm
tomorrow
saying
again,
whether any
this-
post is required, they will do it. That's a
But-
different. But it's just for example,
Yes,
for the purpose of sweeper.
lots of.
The question of a person
Question.
being pointed out that does not arise in view of the government's own decision, that it has to be outsourced.
My lord.
As regards the peon, if it is necessary, then you have to give a justification. Why it is necessary, you give a justification to that. And the finance will look into it. How long would it take for you to give the justification? 10 days,
2 weeks, my lord.
7 days. 7 days. 7 days you can give the
My
justification.
lord,
You have to give a justification to the finance. The finance will work it out
Hmm.
and give the post facto approval and give a decision that within a particular period of time you have to finish it.
Lots.
We are going to, or the finance may be magnanimous enough and say that only for this year. And in future, don't extend beyond without taking our proposal.
Lots.
So that can be done. So for this year, I think you should give it as he has already worked, but we give a clear stipulation in your order to that effect that there shall not be without finance approval.
My lord.
So, and thereafter, if the officer does, that is his headache.
Only thing, is, my lord, member is on leave. Let it be after 2 weeks. She is on leave, my lord.
This is in her office.
Justification to end.
Justification can be.
Chalo. Heard Mr. S. Samaria, the learned counsel, appearing on behalf of the petitioner. Mr. B. Gogoi, the learned additional AAG. The learned AAG appears on behalf of the state of
1, 3 and
Assam
4.
as well as the finance department.
Right.
Mr. G. Bushra appears on behalf of the respondent number 2, 4, and 5. The petitioner, who is a casual employee working under the establishment of the respondent number 5, isn't it?
Yes, ma'am.
Respondent number 5 is aggrieved by the non-payment of his monthly remuneration, which is rupees 9,000 per month from the month of May 2025 till date. From the affidavit in opposition filed by the respondent number 5, it transpired that steps were taken for payment of the monthly remuneration for the month of May 2025 by the office of the respondent number 5. However, the respondent number 6 have rejected the said request on the ground that there was no finance approval taken prior to extending the services of the petitioner. Full stop. This could also have taken note of that when employees are appointed, persons are appointed on casual employment, they are appointed for a particular period depending upon the finance approval. The materials on record do not show shows that the petitioner herein was services were extended until further orders by an order dated 28/3/2019. And thereupon the petitioner have continued to render service as a casual employee. The finance department was also making the respondent number 6 also was releasing the payments without any objection. The question of the finance approval was only raised when it came to releasing the monthly remuneration of the petitioner for the month of May 2025. It appears from the materials on record that what is required, the materials on record, that what is required is that the respondent number 5 should submit a proposal to the finance department seeking the ex post facto approval for engagement of the petitioner for the period from 2025, from 1/4/2025 to 31/3/2026. Or such other period, but not exceeding the 1 year as stipulated above. Inasmuch as these proposals, it is on the basis of such proposals, budget is prepared. However, there appears in the present facts that there was no proposal so submitted by the respondent number 5. And more particular, and the reason appears to be that all these years from 2019, without any such proposal, there was no objections raised in the defrayment of the monthly remuneration of the casual employees working in the establishment of the respondent number 5. Considering the above, this court fixes this matter on 9th of September 2025. The petitioner, the respondent number 5, is directed to submit a proposal to the finance department. To whom should it be submitted? To the judicial department. To the judicial department of the government of Assam. And the judicial department shall thereupon forward the same to the finance department for the consideration of the proposal as regards granting of ex post facto approval for the period sought for in the said proposal. The said, the respondent number 5 shall do the same at the earliest, so that the finance department can give an update as regards the post facto approval as to whether gives an update as regards the consideration of the ex post facto approval on the next date so fixed.
Item 3,
Proposal with reasoning. The reasoning word may be added.
Huh?
Proposal with justification, my lord.
Proposal with justification. Use justification for retention of the. Mr. Gogoi, we need to, but Mr. Gogoi, I'll tell you one thing. Yesterday, me and Justice Chaudhary were taking at the toilet matter. In that order, I have quoted one paragraph. Paragraph 11 of a judgment of the Supreme Court dated 21/2025. It is reported in 2025 SCC Online, page 81. There is a specific direction upon the state to provide funds by the Supreme Court, and it is being monitored by the Supreme Court. So therefore, my direction is no longer there to anybody. My direction now is to the Chief Secretary. To the Chief Secretary, to the Finance Commissioner and AR for providing all the details. There is no part meal basis out there. Huh? An order I have asked if the registry to furnish it to you. Because now the Supreme Court is monitoring under 142 as to what is how, and the High Court has to keep on giving quarterly report. All the High Courts are given. We are also. Yes, Mr. P.K. Roy Chaudhary. What is this now? After, is there nothing to do all your service matters?
Lordship, on last occasion, I was supposed to take instruction whether the mahal was put to sell again or not. It was again,
That is
Yes, yes.
interesting matter.
it was given
Whether
to the
it
second
has-
highest bidder.
because if it is less than 5 hectares, you can't put it to sale.
But it was given to the second highest bidder. It is more than 5 hectares.
Huh?
It was given to the second highest bidder for 7 years, for lease of 7 years. LOI was issued to the second highest bidder.
Then when did you do it?
We did it on 2018, Your Lordship. 5th of November 2018.
And when did you impose this thing on this?
5/12/2018.
So you want double benefit.
Not double benefit, Lordship,
No,
because
then
because
why are you asking them?
because he's failed to deposit 25%, Your Lordship, the initial bid security. He has deposited only 15%, 10%, and 15% there still remains. Thereby, he was asked to deposit the remaining 15%, which he did not deposit. Thereafter, he approached this court. There's an interim order. That's why we cannot even proceed with the Pakistan proceeding against him, Your Lordship. Even he was blacklisted for 5 years, the petitioner.
5 years.
Yes.
Hmm?
5 years of blacklist question.
I don't know. I don't have the instruction whether they have blacklisted me for 5 years. That instruction is not with me. But only one respect that I got the mining plan that was approved. The area was 5 hectares. And if I read Rule 24, it says, my lord, subject to sub-rule 2 of Rule 23, permits for mining of minor minerals may be granted by the competent authority for extraction of minor minerals in respect of area ordinarily less than 5 hectares. It should be less than 5 hectares. If it is, if I read
No.
Rule 24,
No.
and the approved plan was, it was 5 hectares.
You can mine 10 minutes.
It was 5 hectares. That's why it was given to the second highest bidder. We did not go back. We give it to the second highest bidder, Your Lordship, since it was 5 hectares.
Yes, what are you reading?
Rule 24, my lord. One.
What about 23(1)?
23 subject mining may be granted cover in respect of any area not covered under the minor already granted under these rules in the following cases. This is mining of respect of area ordinarily less than 5 hectares for a specified annual quantity, less than 5 hectares.
That is subject to Rule 5, Your Lordship.
Subject to Rule 5,
Five.
mining of so and so in an area not covered under any mineral concession already granted under the rules in the following cases. Mining in less than so and so, less than 5 hectares area, in a case where there is a serious so and so. For any year where a serious or for this demand shall be. It doesn't say that it should be less than, it can be given below 5 hectares also. But it cannot say that it does not, it cannot be granted above 5 hectares.
That's true. That's not specifically written. That's not
So
given.
ordinarily,
Ordinary.
May be granted
in respect of areas ordinarily less than 5 hectares.
less than 5.
Less than 5 hectares.
Ordinary.
Ordinary. So that doesn't apply to. And in fact, this already on 2018, the second highest bidder was given the LOI. In 2018, the second highest bidder was already given the LOI. The petitioner was blacklisted for 5 years. Even his blacklisting period is already over. The
But-
only issue here is that the petitioner being the highest bidder, he has to deposit 25% of the initial bid security. He deposited 10%, 15%. 10% still remains. He did not deposit that. So that's why we asked him to deposit remaining 10%.
But
Thereafter-
for the period, only for 2 years, because from 14 to 18, there was a stay order filed by somebody. From 14 to 18, I got it in 13. And up to 18, there was a stay order. So I could not do anything. In 18, they say you give me the balance 10% for another 2 years. Then when I said that I will not be able to continue with this because some other difficulties of me. So that is why this impugned order, which I have came before this court. I made a representation that I will not be in the position to give. Because from 14 to 18, I was not being
So
able to.
what happened to the representation? Have you considered it?
No, Your Lordship, because he said he cannot run, he has to submit a surrender application, Your Lordship.
Huh?
He has to submit a surrender application.
That he did not.
Did not.
Page 25.
I request you kindly to look into the matter. But this was given subsequently, or this was given earlier.
28, 2018. The impugned order is of 20.
And but after this,
Hmm.
they have taken up that action.
Yes.
5/8/2018, then you were given a notice.
Of 5/12/2018.
You were given a notice
Madam.
and you have not. You have deposited in it. What happens to the earlier amount, other amount?
11 lakhs that I have paid, madam.
The earlier amount, it's with the department only.
He has paid certain amount.
He has paid only 15%.
No, madam. Total I have paid 11 lakhs.
He has paid 11 lakhs. Na?
11 lakhs 61,680. That is their document which shows, my lord. Your lordship will find their document at page 18.
Ah. 11 lakhs
61,680.
being 10% of the initial bid secured.
That's only 10%.
1 month's annual contract money and 10% of the additional amount as asked for restoration and rehabilitation. So 11 lakhs 61,000 constitutes these three components.
These three components. And the rest 15 he has to pay. Because 25% it has to come to about 25%. As per Rule 37, Your Lordship, of the Assam Mining Concession, the highest bidder has to pay.
Yes, 37. Payment of the bid amount.
Payment, bid amount.
My lord,
Shall be
she says the process of
regarded as
completion of
successful
various
unless
stages.
accepted by the officer competently. The highest bidder shall be required to deposit an equal amount equal to 25% of the equal debt rent as security advance along with an additional amount equal 1 month's debt rate advance. Process for completion of the variant. Completion of the bill process that is highest bidders and according to the initial amount of bill received of the initial security report. The amount deposited must be initial bid security. Just the bid security accepted. Letter of intent was issued.
No. Letter of intent was not issued.
That this one is letter of intent, page 14.
Now, only come to letter of intent issued.
My lord, page 14, your lordship will find.
Issuing a letter of intent, your lordship.
Huh?
The PCCF has directed DFO.
Letter of intent granting of mining permit to.
Yes, it was issued, your lordship. Page
Has been
15.
Issued, na?
Issued, page 15.
Very. On receipt of an amount of fees so and so. You are hereby requested to start the process of preparation of remand and submit. Is this a letter of intent?
Page 15 is a letter of intent, lordship, issued by the DFO to the petitioner.
Issue of letter with reference to the above. How these people have put it now? Petitions should be dismissed with cost upon the council. Use cost. With reference to the above and subject to the appeal provisions and other provisions of the Assam and other and provisional letter will be issued to you for granting of a mining contract or respect of the mining area. You are to deposit the initial bid security amount and amount equal to 10% of the initial. One. Deposit an additional amount of 1%. No. This is a provisional.
Provisional.
This is not the letter of intent.
This is a provisional letter LOI.
No, you see, kindly see page 15.
On the receipt of this provisional letter of intent.
You should deposit the
In-
initial bid security of an amount equal to 10% of the investment. Now kindly come to 37.1.3.1. So 37.3.1 conceives, although do not conceive of a provisional letter of intent, but you are to pay the initial bid security of 10%,
10%.
which he has paid.
Paid.
Along with that, he has paid 2 and 3.
2 and 3.
That has been paid.
Paid.
But have you issued this number two?
The amount of because in the meantime, there's a read petition file. There was a stay order.
But you have not issued the letter of intent.
No, because he has deposited. Yes.
You have not issued the letter of. If you have not issued the letter in intent, where does 37.3.3 come?
History.
This is a letter of intent holder. The letter of intent holder, your lordship.
So therefore, 3.2 says, after you receive the initial bid security, which you have received, along with the other two, you say that kindly give me, then you are going to issue the letter of intent. When a letter of intent is being issued, then he becomes a letter of intent holder. Then there will be a requirement of paying the 15%.
The provisional letter of intents.
That's not conceived.
Okay.
So therefore, there is no provisional letter of intent. What happens is the moment you have the hammer, who is the highest, you ask him to deposit
10%.
10%. Here, what you have done in writing, you have therefore says put the term as provisional letter of intent, although the rules do not prescribe. So accordingly, thereupon, after 7/1/2014, he filed. He deposited this 11 lakhs. But prior to the issuance of the letter of intent, the writ petition got filed.
File.
There was a stay.
Stay.
Did you issue thereafter the letter of intent?
No, we cannot issue because there was stay order in that Mahal, Your Lordship.
After that.
After that, we were asked him to submit the mining plan.
Understood, but did you issue the letter?
No,
of
because where is the mining plan? He didn't submit the mining plan.
So therefore, without a mining plan, it is not mentioned out here. That mining plan is required as per 37(3). But what do I mean? It is required to submit the mining plan as is required under the rules.
Yes.
Some other rule. But whatever may be, you did not issue the letter of intent.
We did not issue.
If you have not issued, where does his liability arise for 37(3)?
And my lord, this is the minor plan we have submitted in 2014. Our mining plan, man.
Is it approved
Not approved. I've seen that
by
it's
the?
by the Director of Geological and Mining.
So mining plan also is submitted, but the fact remains that because of the pendency of the matter, you did not issue the mining plan the note.
Letter of intent.
Letter of intent. And if you have not issued the letter of intent, 37(3)(3) does not come into play.
The whole issue is that the provincial letter of intent, whether it comes to this, holds the field of the letter of
But
intent holder.
written out here in the
The
provisional-
letter of intent holder.
No. The concept of provisional letter of intent is not there.
Not there.
What is there is putting the hammer, you ask him. Now when you ask him, you put it as a provisional intent, letter of intent. So you tell him that kindly deposit the 10%.
Hmm.
This is a action taken under 37(3)(1).
3-1.
And this is also specifically mentioned. Then after being satisfied with all this amount, you are required to issue the letter of intent. Letter of intent, if you are issuing, then he has to deposit.
Deposited another 15%.
But without issuing the letter of intent, how can you demand that amount of 15%? You need some time to look into it.
I need to go through this provisional letter of intent,
Because obviously,
Yes,
this is not the submission of or the
it's in the rules a lot.
2 o'clock.
2 o'clock.
Because we need to finish. Because he is only questioning, okay, the imposition of 15%. I'm not going to go for the refund. Refund is gone. Only the 15% is needed. But, after all, nothing has happened. So one has to take a more reasonable view and give him whatever it is. But the other 11 lakhs, nothing. Money has gone. Because he did not surrender.
Surrender.
To get back that money, he needs to surrender, which he has not done. And he just wrote a letter out here. Look here, I don't want to do any business. Need to surrender.
True.
You look into it. If I'm right or wrong.
Lordship, engage was Mr. Soike's court number 4, Lordship. Lordship, when you
Who?
take him to M. Soike, move to M. Soike, Lordship. He's in court number 4, Lord, in another method. Finally taken into method after some time.
I have the instructions back. The clarifications that my lords had asked for, I have them back.
What is it?
My lords had on the previous occasion put forth a query as to whether the APDCL while carrying out the assessment had taken note of the formulas, my lords. Now I've received the instructions.
Whether 7.4.2,
Yes.
1C as well as 7A and B been followed.
Yes, my lord. Now the issue is as far as 7.4.2 3AB is concerned, my lord, that provision was brought in by way of an amendment in 2019. And this is an assessment carried out in way before that, my lord. So that it is not applicable in the present case. 7.4.2 has been applied.
This was done in inspection in 2018.
Yes, inspection of
Though
2018.
the petitioner had a sanction load of 635, but there was an excess unauthorized connected load of here. Therefore, as per the inspection report, the excess unauthorized load was not. It is further pertinent to take note that in terms with the inspection report, 169 of the excess done was found in the and to that, what was there?
Prior to that, the previous formula, my lord, the other provision of clause 7.4.2, that has been followed. In fact, it is part of the assessment. It is part of the records before, my lord. This set of instructions that I've placed, my lord, it also has the calculation at page 3. My lords will see that clause number 7.41 and calculation as per ARC 7.4.2.
Which is the part of the record?
It is, my lords, as part of the page 60.
Now, what you do at page 105? Come to 105.
105.
This is
Yes.
the order passed by the
AERC. But my lords will kindly see at page 106 what the ARC finally does. It remands it back to the authorities to file an
No, can you
application.
come to 105?
Yes, 105 there is a finding.
So with this finding being there, then how do you do it in any other matter?
It only says, my lord, connected load under clause 7.4.2, which has been done in the present case, my lords.
Will not be applicable. Now you see that the assessment on the basis of the detected connected load under 7 point so and so will not be applicable when the actual demand can be determined from the record of the MDI meter.
Yes.
So if this is being so, this is the direction. That if there is an MDI meter, then you cannot do as per 7.4.2.
Yes.
What you require to do, if it is not only, it is only when you have an MDI meter, then you can do. If not equipped, then you can go for 7.4.2. So under such circumstances, if he has an MDI meter, what is required to be done is as per this one, new one.
The new one was brought in 2019, my lord.
Maybe, but this is the wrong thing. That day also one matter passed came by the Mr. SP Sharma.
Well.
In case of connection equipped with MDI meter, no assessment shall be made by unauthorized extension over and above the connector as per agreement. Penalty for drawal of excess rear shall be levied at 3 times the normal traffic for the portion of demand exceeding the contract limit. You have to do as per this.
This is subsequent to the assessment.
Understood, but this is wrong.
And as far as the ARC.
And the assessment is the appeal is the continuation of the assessment.
Yes,
Can't help it. First of all, you are therefore, you see, you make an assessment, provisional assessment under 126. Thereafter, you make a final assessment under 126. After making the final assessment, there is a scope of appeal under 127.
7.
Now, therefore, it is a continuation. Once it is a continuation and the appellate authority holds this, the assessing officer has to do it unless you challenge this.
Well, the subject to what Lordship says, my lord, the observation of the AARC. Then AARC finally, my lord, what it does is at para 11 at page 106, it says Commission will not interfere with the assessment bill raised by against so and so. This shall be dealt with in accordance with relevant provisions of the Electricity Act. Now, following this, my lords, an assessment was carried out. The matter traveled to this honorable court, my lord. The parties had challenged the provisional assessment, and what eventually, my lord, had happened, this matter was again remanded to the appellate authority under 127. So the AERC order perhaps
No longer remain.
no longer remain. Same party, my lord, same fact.
This is blueberry industry.
Yes, yes. Page 3 of the order, my lords.
But this is rose bandit estate.
This is Rose Candy, my lords. My lords, I'm referring to the observation of the AERC at page 105, as pointed out by my lordship. My lord. That very same matter at page 3, my lords will see the same party. Same assessment amount.
Or Sinpac.
Yes, my lords. The same assessment amount, my lords, will find at page 7, para 5.
860. Petitioner is a private limited along with one of its directors area. The petitioner deals with construction and maintenance of air. Likewise, the petitioner in the first petition. The petitioner has to challenge the speaking order dated passed by the APD itself pursuant to a remand by the court. By the order dated 19/12/2018. By the speaking, the representation of the petitioner was rejected, which was filed against the assessment order dated 12.
Then eventually, my lords will see the final.
What is the date of this order?
This order, my lords,
103.
it's 14th March 2023.
How do you get the date?
The
8/10/2018.
yes.
8/10/2018. Thereafter, likewise, the petitioner in the petition, the petitioner has put to challenge the speaking order dated 19/1/2019. What is that?
19-1, because the AERC had directed the APD cell to dispose of a representation.
So after this, there was a fresh assessment made.
Press assessment. My lord, the representation was disposed of.
No, no.
It-
After this
was-
order, 8/10/2018,
Yes, my lord.
there was a fresh assessment made.
The assessment remained the same because from why I'm saying this, my lords, at page 103 of the writ petition, para 3, my lords will see the assessed amount
Of this petition.
of this very writ petition, my lords. Item number 4. The amount, the penalty bill of 19,96,854
Wait.
at para 3, my lords. Second line from the bottom,
Which
para
petition you are referring to? 81.
81, my lords.
There are a team of officials.
103, page 103, my lords.
Oh, 103.
At para 3,
19 lakhs 96.
19 lakhs 96, my lord. And
So
now
this is done as per the petitioner on air received the penalty bill of.
yes, this is the assessment bill.
Okay.
Now, as far as this, the copy of the order of 24th March that I passed in Sinfac, my
This
lord.
is 11/6. So this 11/6 is being challenged in petition number 13 of 2018.
Yes. Eventually the ARC, what they,
ARC passes an order that you do as per the MDI meter.
even the direction is, will not go into the assessment. This shall be dealt with in accordance with the relevant provisions of the Electricity Act. Matter is remanded to the APDCL.
Now, understood. Paragraph 10 say that in view of the implied cause in so and so, the assessment on the basis of connected load so and so will not be applicable when the actual demand can be determined for the record of the MDA meter. So this is what has been given at 10 Roman 3. Thereafter, there was another assessment being made.
Well, if I may, Manoj, 10, the observations are made. Para 11, Commission holds that we will not interfere with the assessment bill. This shall be dealt with in accordance with the relevant provisions of the Electricity Act. So based on this order, a representation was filed by the very same entity, SINPAC. Before,
How did the representation come into the being?
on the basis of the observation, they had sought for modification of the assessment. Now, that very order.
Where the representation is not here.
No, it is not here, my lord. It is recorded in the order that I just passed, my lord.
This one.
Yes, my lord. In WPC 860, my lord.
No, they filed a writ petition against that order.
Yes. Now,
Put challenge passed by the APDCL pursuant to the remand by this court in so and so by the order dated 19/12/2018. This is the problem I'm finding. There's a speaking order dated 19/1/2019. Where is that?
I do not have that. Perhaps that would be necessary. Because, but what I wanted to
Because
show
you
is,
see,
my lord.
Mr. Chaudhary, there's a difference in the amount.
Yes.
Here the amount is 19,96,854.98. Whereas in that case, it is 0.91.
Yes. 0.7.
So
Yes.
how do I say that this is same with that?
Well, I'll confirm this, my lord. I'll have to confirm this, my lord. Yes. Public revenue, my lord, at the end of the day.
Yes, to public revenue. So an appeal was directed to be filed again.
Yes, 127.
Again, another appeal was filed.
Because no, what they had done was, without exhausting their remedy under 127, they had challenged the final assessment by filing a writ
Then there was a direction to submit a
for them to go
representation.
back to the appellate authority.
No, the directed to submit a representation.
Yes.
This was challenged again in writ appeal. This is the writ petition.
Writ petition.
So this writ petition passes an order that, okay, now you file a writ appeal.
Appeal under 127.
So they filed an appeal.
Yes.
Where's the order of the appellate authority?
But that order I do not have. But what I wanted to show was, my lord,
No,
the,
you say that the earlier order does not hold the fee
yes,
because of a subsequent order being filed.
yes,
But the question is whether any order has been passed in pursuant to an appeal subsequently filed and again under 127.
my lords. Yes. As far as this proceeding, I'll have to get that there, my lords. Because what I wanted to project, my lord, subject to what lordship holds, this observation of the AERC perhaps does not hold the field because there have been certain other directions flowing from higher authorities, my lords.
Let us see, he must have stated in his memo of appeal, wait. Final assessment bill is made here. Kindly come to page 110.
110. Yes, my lord.
The appeal as such, the appellant approached the Honorable High Court by the order dated Honorable and directed the appeal to furnish the document considering the final order passed. Agreed by such approach the High Court and by an order reverted the matter back to the appellate authority. The statutory authority and giving concession from the statutory 50% agreed by the initiation of assessment without following the procedure of law and passing the final order of assessment under so and so. There is no relevance to these matters.
No, nothing, man. They have not pointed out anything. Man.
You have also not pointed out. Now he is challenging the second, again the assessment order by this procedure. Isn't it?
Yeah. by way of item number 4, my lords, he challenged the order passed by the appellate authority. However, the order of the appellate authority
Now, the
actually,
appellate authority is there, 8/12/2023,
yes,
25/10/2023. What does it say? Let us see it.
yes.
The assessment on unauthorized use of electricity by the appellant may be made as per section so and so on the quantum of excess demand found unloaded for the 12 months and double the tariff charged only prevailing at the respective period. If any advance payment and overdrawal penalty were recovered from the appellant during the said 12 months, as well as the deducted from bill, is to be regularized by observing other formalities as per age. So here there is a direction to do it as per this.
Yes,
Be made as per 126 on demand on the quantum of excess so and so. Load found connected for a period of 12 months at the double the tariff fixed charge only prevailing. Now this is double the tariff is given under which provision?
7.4.2 itself.
Hey, could you regulation? Regulation. Hey, Gonigon. Tolo. Assam excise or excise or tolo.
Yes, it is under 126 of the Act, my lords.
So this is as per 7.4.2 Roman 2.
Yes. And as far as the,
This is exactly what has been passed. 7.4.2 Roman 2.
Roman 2. And the
7
requirement of
4.2
assessment at twice, my lord.
Now, only 3 has been inserted.
3B.
3 has been inserted later on, 3B,
Yes.
in case of method of assessment for demand and energy charge. Earlier, what was 7.3? So if it is done under 7.3B, A small b,
Yes.
then it will be more. Because here it is shall be made at rate twice of the applicable tariff
Tariff.
in accordance with the provision excluding the amount of bills related to the assessment period paid by the consumer. Meaning thereby, just for example, if it's the taking into account the excess load or the total load for that period, it has to be multiplied by 2.
2.
And then subtract it with the amount he has already paid.
Yes.
This is 7.4.2 Roman 2, isn't it?
Yes, 7.2 Roman 2.
7.4.2 Roman 3 for assessment of demand charge and energy charge. Then in case of connection with MDI, in connection with MDI, no assessment shall be made for unauthorized extension over and above the connected load. As per the agreement, penalty for drawal in excess of the contract demand shall be levied at 3 times the normal tariff for the period portion of the demand exceeding the contract demand. Now, what was there in 7.2.4.2 Roman 3 prior to that? Because this amendment shows that in the year 2017, it's 19, this
19.
amendment was, it's a case of substitution. If you see clause 4,
Yes.
regulation 4.7.4.2 Roman 3 of the principal areas shall be substituted,
Yes.
meaning thereby there existed something else. Isn't it?
Yes, my lord.
You need to take that instruction, huh? Mr. B. Chaudhary, the learned counsel appearing on behalf of the APDCL, submitted that pursuant to the order passed by this court dated 24/7/2025, he has obtained the instruction, and as per his instruction, 7.4.2 Roman 3 capital A small b of the AERC Electricity Supply Code Regulation 2017 could not have been applied, taking into account that the assessment is for the period in the year 2018, and there was an amendment being made to the regulation of 2017 by the Assam Electricity Regulatory Commission Electricity Supply Code close Regulation 2017 First Amendment First Amendment Regulation 2018, which was notified on 3rd of January 2019. This court have duly taken note of the said notification dated 3/1/2019, and from clause 4 of the said notification, it transpires that clause 7.4.2 Roman 3 of the regulation was substituted and was substituted. The word substitution being used, this court inquired with Mr. B. Chaudhary, the learned counsel appearing on behalf of the APDCL, as to what were the regulations which were substituted by Regulation 7.4.2 Roman 3 by the amendment made in the year 2018, given effect from 3/1/2019. List this matter again on, when do you want it? Let's have it after I come back. I'm coming back on 4th, 5th. Let it be on 9th.
9th of September. Yes, ma'am.
This is the matter on 9th of September for further hearing.
Deeply obliged.
Obliged, Lord.
Item 6.
Either way. You're silent. Yes, Mr. Sharma.
Maybe,
And Mr. R. Gogoi. What is
there
this?
is,
I was
With
given,
regard to lack of action on the part of the department to issue the IMFL license to the petitioner, it is the case whether that pursuant to his application, the necessary approval was accorded by in 2022. It's a matter.
Yes, Sir Lordship. Lordship, what has happened here is that the government has taken a decision to not to issue any more IMFL on license in rural areas. So what they did, they converted this on license into off license, Your Lordship. So that's why the process is taking time, because his license is one of those licenses which will be converted to off license.
now, my lord, almost, my client
So
is
you will
agreed.
have a shop, not
Huh?
a restaurant.
Yes, he'll have a shop, not a restaurant.
No, I have constructed my lord borrowing for 22 lakhs on my land.
Are you okay with the shop?
Yes, that's what I'm submitting. So I had spent for unlicensed bars, everything was of, constructed. Then suddenly they come, they disturb cabinet decision. So my lord, cabinet decision came after the license issued to me and I distributed the money. Now they want, the government wants that distribute of license. Even even if I win the case, tomorrow they will file 10 complaints against me. So ultimately they will cancel it. Tomorrow I am agreed to of license.
You agreed.
Yes.
So what should I do?
Yes, my lord, will pass the order that the proposal given by the government.
I'm giving you liberty. If they don't issue the off license,
Yes,
you again approach police court.
yes, yes.
Then I think that is a fair
Yes, yes.
order. Mr. R.P. Sharma, registered by so and so, appearing on behalf of the petitioner,
Ms. K. Decker.
and
Yeah.
Mr. R.R. Gogoi, the learned counsel, who standing counsel,
Excess.
appearing on behalf of the Excise Department of the Government of Assam. From the materials on record, it transpired that the petitioner had applied for on license, IMFL on license. In the district of Dhemaji. The various formalities were duly completed. And the government of Assam and the additional secretary to the government of Assam Excise Department had issued a letter to the deputy commissioner, bracket, renamed as district commissioner, bracket close, Dhemaji, that the governor of Assam, under Rule 116 of the Assam Excise Rules 2016, was pleased to accord sanction on the IMFL on license in favor of the petitioner in the district of Dhemaji for a period of 1 year and subject to renewal under Rule 128 of the Assam Excise Rules 2016 on year-to-year basis. The petitioner thereupon approached the respondent number 4 for issuance of the said license, but the said license was not issued, for which the petitioner has approached this court. It is the further case of the petitioner that on the basis of his applications of file and the according of the permission sanction by the governor of Assam, as intimated by the communication dated 12/5/2022, the petitioner had invested an amount of rupees 20,70,000 in facilitating the structures for accommodation of the IMFL on license shop. Being agreed, the petitioner had submitted various representations, but having not received any favorable response, the petitioner has approached this court seeking appropriate directions. It is seen that this court, by an order dated 22 28/2/2025 issued notice. An affidavit in opposition has been filed by the respondent number 4,
District Commissioner.
wherein it has been mentioned that
Para 7 was.
the said respondents have received that the said respondent had issued 2 communications dated 27/5/2022 and 28/8/2023 to the Commissioner of Excise and the government of, in respect to the issue, excise, in respect to the issuance of the IMFL on license. It was further stated in the said affidavit that the cabinet had taken a decision on 23/5/2022 that no new IMFL on license would be issued in the rural areas. And it is under such circumstances the District Commissioner, the respondent number 4, is not in a position to issue the license. It is further mentioned that the respondent number 4 is further awaiting appropriate instructions in that regard and have also issued a communication on 1st of March 2025. Today, when the matter is being taken up, Mr. R.R. Gogoi submitted a set of instructions as well as the cabinet memorandum, cabinet decision, wherein it was resolved that IMFL retail on license in rural areas would only be issued to tourist resorts, lodges, and hotels.
Yes.
And that too subject to recommendation from the tourism department. The said documents are kept on record and marked with the letter X. Mr. R.L. Gogoi, the learned counsel, further submits that taking into account the petitioner's application, the respondent authorities are taking steps in terms with the Assam Excise Act 2000,
2016.
as well as the rules framed therein under. For the purpose of issuance of a IMFL off license to the petitioner. And this aspect would take some time, as there are various technical, various procedural formalities Mr. R.P. Sharma, the learned senior counsel, submitted that though the cabinet had taken a decision, but the petitioner had applied for the IMFL on license prior to the cabinet decision. However, as per his instructions, that the petitioner would not insist for the IMFL on license, but would be contented if the IMFL off license is issued to the petitioner. This court, having taken into account the submissions so made by the Standing Counsel of the Excise Department, that procedural formalities are being taken up for the purpose of considering as to whether the petitioner IMFL off license can be issued, this court would not like to keep the instant proceedings pending, taking into account that the Assam Excise Act, as well as the rules framed under, provides due powers upon the respondent authorities to consider the same within the mandate of the Act as well as the rules. Be it as it may, this court observes, and accordingly, this court therefore closes the present writ petition with the observation that the respondent authorities shall duly consider the case of the petitioner for the purpose of IMFL off license, if so permissible as per the Assam Excise Act as well as the rules framed therein under. And if the petitioner is aggrieved by such non-consideration, petitioner would be at liberty to approach this court again.
Obliged.
Supplementary item 22 and 23.
You filed the affidavit?
May it please the Lordship. Yes, Your Lordship. We have filed the affidavit. It's fine.
Where is Mr. S. Bonik? So, Mr. Bonik, I do my formality now.
But I understand that so far as the authorities are concerned, they have taken a stand, and as per their stand, they've chosen to take 4 years, average for 5 years, since obviously, I must be fair, there would seem to be a substantial compliance on that count, coupled with the fact that I could not score 60 and above. The fact is against me. If my Lord permits, I may point out two things which may perhaps form a part of the order. The first thing is that relaxation, as per the judgments, of course, prevalent, is always within the domain of the authorities. But relaxation, insofar as a non-responsive bidder is concerned, if we take the words of the tender and understand it in a very simple manner, the permissibility of that relaxation is writ large. To that extent, I invite my lords to page 41 of the writ petition, if lordship permits. Otherwise, I wind up my case. I rest my case. Otherwise, I just want to bring home that point. I squarely understand. Page 41, number 3. the last part. Eligibility criteria of the bidder. I would not read all, Lordship is there in 41 perhaps. Eligibility criteria of the bidder. All bidders shall include the following information and documents with their bids. It does not talk about the essential terms or mandatory or whatever. I would go by that. I'm taking to take a very neutral view. Now, as we go to page 42, there are indications which say at point 5, minimum average turnover of rupees 1 crore for the last 5 years, financial reports for the last 5 years, balance sheets, profit and loss statements, auditors' reports in case of companies, corporation, etc. Down below, bidders who do not fulfill the requirements need not participate in the bid process, and that too in bold, meaning thereby, in their own estimation, they considered it to be a mandatory essential clause to the extent that if anyone does not confirm to that, need not participate.
Where you a company?
No, I'm not on that.
Who are you?
No, we are a MSME. I'll just check it up. Firm.
Madam.
Yes,
You
sir.
see,
Yes,
Mr. Bonik will take some time.
yes, Your
No, I'll not take some time. I'll just point out. So if they are putting it in bold letters,
Who are you?
the participant, I'll just put it in the technical terms for optional, proprietorial concern, proprietorial concern. So if they put up in bold letters that 5 years, I'm only on that, I understand what is following, that 5 years turnover is required. They may go by that, they may not go by that, substantial compliance.
Did you submit your balance sheet for the year 2021?
They might have by the records, I'll check
I'm
up.
asking you.
I'll check up, because we submitted
could not
everything.
have. You
Why not?
could not have submitted. Taking into account that the period of preparation of a balance sheet as per the Income Tax Act, an individual would be in the month of July.
My lord.
For a firm, it would be in the month of, for a company, would be in the month of September or October.
But
So the question of those balance sheets being available in 2021-22 doesn't arise. What are you required to submit? There are various documents. So what they did, they duly submitted what was available to them. Now, if you see paragraph 15 of accounts,
my lord.
they may be right, they may be wrong,
Oh, correct. Absolutely.
but it is perverse.
So
No.
far as AFCONS is concerned, if I go down to Jagdish Mandal, the part whether it's tailor-made to suit someone. AFCONS has Jagdish Mandal 714 has a twin test. I'm not unreasonable to arbitrariness of it, but whether it's to suit someone, the action per se, and whether it's an off-the-cuff reasoning by way of affidavit or it stems out from the record. A decision reached by the authorities on the record, I would not have a say in view of the judgments holding the field. So materially,
No, it cannot be off the court because
they must have it.
What they have considered, they have not considered the period from 2006, 2016, 17, they have not taken into consideration. If they had taken into consideration, they did not take. They took it from 17, 18.
Their
18,
affidavit,
19.
their affidavit speaks in two ways. First, they say the bid rejection criteria by clause 10 did not have this thing to be a ground for rejection. Therefore, they could not reject. That how far as acceptable, we leave it to that. Clause 10 says, if I understand correctly, a person or a
No,
entity
Mr. Boni, what they say is different. I'm not on those.
my lord.
What has been stated to me on the other day,
My
I've only asked them to put it on affidavit, which they have put it.
But if it's
2016, 17, they didn't take it. But 2017, 18, 18, 19, 19, 20, 20, 21, having been taken, then also they have more than a crore as an average for 5 years.
absolutely, if
So
this
therefore, they say that we have taken the 5 years to that effect, although they have submitted from 2016,
Correct.
17, we have not looked into.
so that would be
One. Secondly, the basic argument of here is that you have quoted, you have given investment of around 28,50,000, whereas for a period of 5 years.
I had a word with my client. They say there's a requirement of bringing in boats. We have the boats, so therefore, over a crore or more would be adjusted therein. The other party would not, we could not find a response with this paucity of time, on the factual part. I said that's a very subjective matter though. So why did you quote that? I had an instruction. They said that no, sir, we require to give in boats. So that boat we already have.
Give in?
Boat. We have the boat. So therefore, a crore and odd, we already have it. So we need not quote more. But I said, okay, we are only on the term that whether you cross 60 or not, a subjective, so I would not put in affidavit because time is so short. But only thing, my lord, if the decision reached to take 4, divide by the denominator 5, check it up 1 crore, and therefore go with relaxation. If that forms a part of the record, my lord, enough.
For that to be considered, I need to retire from here and let these people appoint me in after my retirement somewhere to consider a tender of your kind.
No.
Then I'll duly invite Mr. Bonik to make a submission as to how do I, and all technical committee meetings, I will make you a member.
The only thing
But
is
now for me now, and let me dismiss you.
but only that part, my lord, whether they have taken that call by the papers.
Mr. As Bonik, the learned counsel appearing on behalf of the petitioner. Ms. P. Borua appears on behalf of the respondent number
2 to 4.
4
2 to 4.
to 4. None appears for respondent number 5 and 6.
5
The
is
matter
appears.
is- Oh, you are there. Then you are not saying? Who appears for 1? Yes, you are there. M. Setia. Appears for the respondent number 1. And Mr. R. Mishra, R.K. Mishra. R.K. Mishra. R.S. Mishra appears for the respondent number 5. 5? The 9 appears on behalf of the respondent number 6 when the matter is called up. The respondent corporation, that is the respondent number 2 herein, had issued a press notice, bracket QCBS, bracket close, e-procurement notice, taking into account that both of you have made lengthy arguments. Take a seat. Bearing number 80 DC oblique 2822 oblique 2017 dated 23/5/2022. Inviting bids for development, operation and management contract for running 3 properties on contractual basis. The details of the properties are: number 1, eco-tourism project at Nameri. Period of contract 5 plus 5 years. 8, page 11 or 18 that year.
Lordship, Dibru Saikhya, it will be. There were 3 tenders, but this tender pertains to Dibru Saikhya. Dibru Saikhya.
I know.
Yes, Lordship.
Pursuant to the said press notice, the respondent authorities, corporation, had issued a detailed notice inviting bid, bracket QCBS, bracket close, e-procurement notice, bearing number 80 DC oblique 2822 oblique 2017 dated 31/5/2022, indicating that bids are invited on contractual basis for 10 years, bracket 5 plus 5 years. In respect to the aforementioned 3 projects. The present petition relates to the eco-tourism. The present proceedings relate to the eco-tourism project at Dibru Saikhya. From the records, it is seen that as many as 9 bidders, 9 bidders or 8? 8 bidders.
Now, 9 bidders, one was rejected completely initially. 8 bidders, fine. 8 bidders.
8 bidders participated in the same tender process. Out of these 8 bidders, 4 were held to be technically responsive, which would include the petitioner, the respondent number 5, the respondent number 6, and 1 MS Santi Enterprise.
Yes.
However, the respondent corporation chose to the respondent number 5 for awarding the contract for development, operation, and management contract for running the newly constructed eco-tourism project for tourist facilities at Dibru-Saikia. It is under such circumstances the petitioner has approached this court by filing the present petition. Challenging the technical bid of the respondent number 5 and 6. On the ground that the said respondents were technically not eligible, and more particularly in view of clause 3 Roman 5 of the eligibility of the, what is this document you are referring to?
It was the bidding document.
Of the bid document. Roman 5 only, Mr. Roman.
We had challenged at page 26 and 27 on the counts.
Roman 5.
No, we had said page 26 qualification information form was not submitted online. Then experience certificate was self-certified. And yearly occupancy, no credibility that whatever self-certification was given. That's what for 5 and we have challenged.
Lordship, actually,
It's only when the records were given, my lord, this thing came up as a part of the proceeding that 4 out of 5 years were given.
4 out of
5 years. This was not put to challenge because we did not know that. Only when the records came that day, then it could be noticed when the copy was served that 5 required years were to be given, but 4 were given. Nevertheless, the average thing was met.
And what are the other grounds?
Other grounds at page 26, my lord, if what you takes up.
And at actually page 30 and 31, they have mentioned that entire selection process, it's vitiated on the following grounds. They have given 5 grounds, your lordship, 4 grounds. If your lordship can see those grounds, it will be, it
The
is
reasons
a
for
paragraph
such
25.
rejection should have been on the following. No, he gave it at page 26.
26.
Had challenged the technical eligibility of the respondent number 5 and 6. Respondent number 5. On the ground. The respondent number 5 had not submitted online the qualification information form, which is contrary to clause 5 of the bidding document. The second ground so taken is that the respondent number 5 had submitted the experience certificate, which is self-certified, which has no credibility on account of self-declaration of experience. The third ground so taken is that the yearly occupancy of 30% as required under clause 3, Roman 3 of the bid document was also self-certified by the respondent number 5, which on its own had no credibility. In respect to the respondent number 6, the challenge made to the technical bid is that the experience certificate so required under section clause 3, Roman 2 was not submitted by the respondent number 6, for which the respondent number 6 bid was liable to be rejected. Further to that, the respondent number 6 had not submitted the yearly occupancy certificate of 30% as is required under clause 3, Roman 3 of the bid document. It is further seen that during the course of the hearing on 29/7/2025, the broadsheet, the technical broadsheet, was produced before this court. A copy of the said broadsheet was provided. Mr. S. Punig, the learned counsel, appearing on behalf of the petitioner during the course of the hearing on 29/7/2025. The learned counsel, appearing on behalf of the petitioner upon perusal thereof, submitted that both the respondent number 5 and 6 did not comply with the requirements of clause 3, Roman 5 of the bid document, in as much as they did not submit the annual turnover for the period from 2017-18 to 2021-22, which was the mandate of clause 3, Roman 5. Rather, they submitted the period for the period from 2016-17 to 2020-21, which is not the mandate of clause 3, Roman 5 of the bid document.
Their response is at page 170 and 171. of the affidavit to the file.
The record reveals that pursuant to filing of the instant petition, this court, by an order dated Li- 9/9/2022, passed an interim order that till the next day, the tender in question shall not be finalized. Thereafter, though notice was issued, the interim order thereafter on 14/11/2022, notice was issued, and the interim order thereupon was continued from time to time, and it extends till date. The record reveals that an affidavit in opposition has been filed by the respondent numbers 2, 3, and 4 on 30/11/2023. In the said affidavit in opposition, it was mentioned the various steps required to be followed for the bid while assessing the bid evaluation criteria. It was mentioned that in terms with the various steps for assessing the bid evaluation criteria, it was mentioned that after opening of the technical bid, cost of bidding document oblique the EMD downloaded from the internet would be opened first. It was mentioned that if the cost of the bidding document is not there or incomplete, the remaining bid document would not be opened and bid would be rejected. Thereupon, the managing director of the respondent corporation would open the cover number 2, cover Roman 2, based upon cover Roman 1, and check the documents submitted with the cover Roman 2. It is further mentioned that after the technical evaluation, The managing director of the respondent corporation shall decide the date of opening of the financial based upon the evaluation report. The evaluation of the financial bid is based upon certain guidelines. And is assessed on a total of 100 marks. The details of which have been given in the table to paragraph number 8 of the affidavit in opposition, and taking into account its relevance, the same is reproduced herein under page 167 to 169. Mr. Bonik, we'll see you after lunch.
Lordship, I'd like to mention item number 1 of today's list. Item number 1, Lordship. If it can be passed over for the day and taken up day after tomorrow.
What is the matter about?
Lords,
Tender matter, my lord.
tender matter
But he's
staycation.
having some medical emergency, my lord.
Lord,
That's
I
why.
hope we-
We'll have it when?
Day after tomorrow or 7th, 8th, subject to Lordship.
Day after tomorrow, I'm sitting only in the second half.
Lordship. Then
I
8th,
have some matters out there. One matter is there.
Friday or
Get
Monday.
your person out there.
Anything.
Let's have it on, in the stay vacating column on Friday.
Lordship, Friday. Yes, Lord.
Dr. A. Todi, counsel appearing on behalf of the petitioner.
My lord,
subjects.
respondent, my lord. I'm for the petition.
You are a petitioner?
Yes, ma'am.
My goodness. Who has the medical emergency?
My friend is doing.
Appearing on behalf of the respondent submit that on account of medical emergency, he has to leave the court premises to take into account the urgency of the matter, list this matter on 8/8/2025 in the stay vacating column.
Much obliged.
One भराई डिपो को लेना, 169 नहीं. It is further relevant to take note of. From the said affidavit. That on the above parameters as quoted, to be qualified for the technical bid, the bidder has to secure at least 60% marks in aggregate. It was further mentioned that out of the 9 bidders, 4 were found eligible, which included the petitioner, the respondent number 5 and the respondent number 6 and 1 MS Santi Enterprise. But in the evaluation so conducted in terms with the parameters, both the petitioner and MS Santi Enterprise could not secure 60 marks and were therefore held to be technically not qualified And on the other hand, the respondent number 5 secured 75, whereas respondent number 6 secured 63. And therefore, on the basis of such assessment being made, the respondent corporation chose to award the contract to the respondent number 5. In the said affidavit, the respondent corporation further stated in detail that the averments contained in paragraph number 22 insofar as the disqualification, so far as the allegation of the respondent number 5 being not competent is totally misconceived, in as much as the submissions, in as much as the allegation that the qualification information form was not submitted online is contrary to clause 5 of the bidding document, in as much as what is stipulated in clause 5 is that the documents as mentioned in qualification information form has to be submitted. And in the present case, the respondent number 5 had submitted all the documents online as per the qualification information form. Insofar as the experience certificate as well as the yearly occupancy certificate being self-attested, it was stated that the said certificates having been self-attested cannot be a ground for disqualification of the respondent number 5. Insofar as the allegations so made by the petitioner as regards to respondent number 6, that the experience certificate as required under clause 3 Roman 2 was not submitted. It was stated that the respondent number 6 had submitted a certificate issued by a chartered accountant to the effect that the respondent number 6 is engaged in the business of running hotel, restaurant and bar for 5 years starting from FY 2016-17 to FY 2020-21. And as such, the mandate of clause 3 Roman 2 have been duly met by the respondent number 6. On the allegation that the respondent number 6 did not submit the yearly occupancy certificate of 30% as was required under clause 3 Roman 3, it was stated that the respondent number 6, while submitting the bid document, had categorically shown that the aroma residency, inverted comma, and a bracket, the unit of the respondent number 6, bracket close, had a property of 36 keys with yearly occupancy of more than 75%. The record further reveals that respondent number 5 has filed an affidavit in opposition supporting the stand of the respondent number 2, 3, and 4 in the affidavit in opposition. Next. As already observed in the previous segments of the instant judgment, on 16/5 to on 29/7/2025, when the broadsheet was produced before this court, the learned counsel appearing on behalf of the respondent number petitioner had further raised the issue as regards the non-compliance to clause 3 Roman 5 of the bidding document. This court, taking into account that the said aspect was not a pleaded case of the petitioner, and it only came into light during the course of the hearing on 29/7/2025, an opportunity was given to the respondent corporation to file an affidavit as regards the non-compliance to clause 3 Roman 5. In this regard, it is pertinent to mention that on 1/8/2025, the respondent number 2, 3, and 4 filed an additional affidavit pursuant to the order passed by this court on 29/7/2025. In the said affidavit, it was mentioned that the NIT was issued on 31/5/2022, with the last date of submission being 27/6/2022. And as such, some of the bidders were not able to provide the financial reports, namely the balance sheets, profit and loss account statements, auditor's report, bracket, in case of companies of the corporation, bracket close, etc., supporting the turnover for the financial year 2021-22, and the same was accepted. It was also mentioned that those bidders who could not submit the financial statement, the documents in terms with the financial year for the financial year 2021-22, duly submitted the annual turnover for the year 2016-17. It is further mentioned that in view of the difficulties so faced by some of the bidders, the respondent number 4 took the average of the annual turnover of the eligible bidders from the financial year 2017-18 to 2020-21 instead of 2021-22. And it was found that even then, even after taking only 4 years of the annual turnover, the respondent number 5 and 6 had the average turnover of more than 1 crore for 5 years. It is further mentioned in the said affidavit that in the PowerPoint presentations so made by the petitioner as well as the respondent numbers 5 and 6. The petitioner PowerPoint presentation was unsatisfactory, taking into account that the investment proposed by the petitioner for development was a meager 28,85,000. And taking into account the reserve price in the NIT being 1,30,000 per month, which comes to rupees 78 lakhs for a period of 5 years, the investment of rupees 28 lakhs 85,000 was found negligible. On the other hand, the respondent number 5 proposed an investment of 2.03 crores for which the respondent number 5 was awarded 31 marks compared to the petitioner only 8 marks. In the backdrop of the above pleadings, this court have duly heard the learned counsels appearing on behalf of the parties and have given the due consideration. The question, the point for determination arises in the present proceedings is as to whether this is a case where this court is required to exercise its powers of judicial review. First, this court have also taken note of the bidding document enclosed as Annexure A or 1A to the writ petition, Annexure B to the writ petition, Annexure C to the writ petition.
See, Your Lordship. See.
The allegations so made in the writ petition that the petitioner did not submit the respondent number 5 did not submit the qualification information form online is belied by the statement made by the respondent numbers 2, 3, and 4 in the affidavit in opposition. Insofar as the self-certification of the respondent number 5 too, the experience and that the respondent number 5 has a property of minimum 10 keys with yearly occupancy of 30%. It is seen that the tender bidding document did not forbid such documents being placed on self-certification. Now let this court duly take note of Clause 3, Roman 5 of the bidding document on which the learned counsel appearing on behalf of the petitioner has emphasized that on account of non-submission of the last 5 years of the balance sheet, profit and loss statement, auditor's report, which should be from 2017-18 to 2021-22. The respondent number 5's bid ought to have been held to be technically not eligible. This court duly takes note of the schedule mentioned in the bidding document, which stipulates that the last date for submission of the manual last date for submission of last date and time of manual submission of the hard copy of the technical bid is 27/6/2022. The respondent number 5 and respondent number 6, a partnership is a part respondent number 5 and the respondent number 6, a partnership firm is a partnership. The respondent number 5 is a partnership firm, whereas the respondent number 6 is a registered company. The respondents, authorities, in their wisdom, were of the opinion, in their wisdom, taking into account that it was not possible to submit the financial reports balance sheet, profit and loss account, auditor's report. For the year 2021-22, considered it that the respondent authorities would only consider 4 years of the annual turnover, that is from 2017-18 to 2021-22, 2009, 2021, 2020-21. And not 2016-17, which the respondent number 5 and 6 duly submitted. And then came to a finding, came to an opinion on the basis of the materials that the respondent number 5 and 6 for the 4 years had an average of more than rupees 1 crore as a minimum average turnover for 5 years. For the last 5 years. This court finds it apposite herein to take note of. That when a tendering authority issues a tender, the settled principles of law opines that this tendering authority has free play in the joints, meaning thereby the tendering authority has discretion to choose the best bidder in terms with who's the best bidder amongst the bidders as per the mandate of the bid document, subject to such discretion being exercised within the purview of Article 14 of the Constitution. The tendering authority in the instant case, taking into account that for registered for companies as well as corporations, it was not possible to submit the profit and loss account auditor's report by the last date for the year 2021-22 chose to disregard the said. However, keeping the minimum average turnover of rupees 1 crore for the last 5 years intact, the said decision of the tendering authority as the respondent authority, corporate respondent authorities in the instant case, even if not acceptable to this court, but the same cannot be a reason for exercising the powers of judicial review. In this regard, this court finds it pertinent to take note of the judgment of the Supreme Court in the case of F. Constable 2016-15 SSC page so and so. And more particularly, paragraph number 15, which is reproduced here in under. First. In the above perspective, therefore, it will be seen There's a question of interference with the decision of the respondent corporation in the present facts do not arise, as this court do not find that there is any infraction to the mandate of Article 14 of the Constitution, or for that matter, the actions of the respondent corporation can be said to be in any manner arbitrary, unreasonable, unfair. Accordingly, this court do not find any good ground for interference, for which the writ petition stands dismissed with cost quantified at 1,30,000 into how many years? 2 years.
Yes.
Pay that cost, 1,30,000, 2 years, multiply by 24. Cost. You have to give them, if they could have, if they have, did not obtain the stay, they would have otherwise got that amount, no? 1,30,000 into so and
What
so.
I'm submitting on the.
Yes.
Anyways. So far as the stay part is concerned, the stay was granted without any condition, number one. And number two,
Yes.
since they participated, there was no urgency on their part to have the matter list. I leave it to your lordship, but cost may not be imposed on this because end of the day, we litigated on merits. End of the day, we litigated on merits. There was
Your, unless they didn't bring the broadsheet, you didn't have a case.
No.
You got a stay on 22 A, B, and C, which has no relevance.
Rather, they filed the affidavit way long without bringing the broadsheet on record.
30,000 into 24. How much?
No, they brought the broadsheet. They filed the affidavit in 23 without bringing the broadsheet on record, Miller. They delayed the matter to the sweet will and now claiming the money. That's the end of the matter.
Hello. In the particular facts of the case, this court is not inclined to possess.
Lordship, there is this other writ petition also that needs to be disposed of.
The earlier one, Miller,
Earlier one.
starting point of time.
The first writ petition that was filed by them, it was filed because we had not included specifically houseboat in clause 3.1 in the eligibility criteria, but houseboat was already included. That's why they got eligible. So they had filed a writ petition challenging that. That is a writ petition.
Here?
First, what was that? In the eligibility condition, houseboat was not included. Although the houseboat, the occupancy houseboat was not included, and therefore we came to the honorable court. Or because the otherwise
Not
rule,
pressed?
it's already they've agreed to it, Not
No,
so we could
already
proceed.
with
Not
the-
pressed?
Not pressed, not.
As Burning the Learning Council submits that he would not like to
Allowed.
press the instant petition. So accordingly, the petition stands closed. I stands closed.
Obliged.
Much obliged. Much obliged.
We may base item 1 through video conference.
Huh? One, two, piece of this one. Oh, yes, madam, can I hear you today? I hope
Your
so.
Lordship. Can you hear me, Your Lordship? Am I audible, Your Lordship?
Madam, I could hear one thing, although my audio is not so proper. But one thing I get it, that you want to reinstate the petitioner without back wages.
Yes, Your Lordship.
Yes. And Ms. Zimomi, you have no objection to that.
Lordship, I leave it to your Lordships.
Otherwise, you didn't have a case. It's because of me you got this case. Okay, we do one thing. You, the instruction I sent you. Have you placed the instruction to the registrar?
Yes,
I've
Your
directed some instruction to be placed.
Yes, we have mailed the papers to the joint registrar as well as to court number 10.
So you will be reinstated without the back wages. So,
Yes, Your Lordship.
Heard. Ms. Jed Zimomi, the learned counsel appearing on behalf of the petitioner. Ms. Livika V. Sumi, the learned government advocate, appears on behalf of the respondent. The petitioner herein have assailed the termination of the petitioner by the order dated 14th of June 2019 on the ground of alleged misconduct. This court, while hearing the matter on 10/4/2025,
Your Lordship, there is also an order dated 8/4/2025.
this court, by the order dated 8/4/2025, while hearing on the proportionality of the punishment this court, this court heard the instant writ petition on 8/4/2025. While taking up the issue pertaining to the proportionality of the punishment, a submission was made on behalf of the respondents that that instructions let be allowed to be placed as to whether the respondents would like to reinstate the petitioner without back wages. This court, taking into account the said submission, fixed the matter on 10/4/2025. On 10/4/2025, this court duly taken note of the submissions so made by the learned counsel appearing on behalf of the petitioner, and as no instruction was obtained from the respondents, fixed the matter again on 24/4/2025 as to whether the respondents would be ready to reinstate the petitioner without back wages. Ms. Livika Assumi, the learned government advocate, have placed before this court an instructions dated 19/5/2025 issued by the Deputy Inspector General of Police, (ADM), Nagaland, Kohima, whereby she was informed that the disciplinary authority is ready to reinstate the petitioner without back wages. The counsel for the said communication being placed is kept on record and marked with the letter X. The learned counsel appearing on behalf of the petitioner submits that though the petitioner ought to have been granted some back wages, but taking into account that the petitioner's livelihood is the question, the petitioner would not insist on the back wages, but would be satisfied if the petitioner is reinstated as constable without back wages. Taking into account the stand so taken by the disciplinary authority, as is recorded in the document kept on record and marked with the letter X, this court therefore disposes of the incident with petition, thereby directing the respondent authorities, more particularly, whom should we direct, Ms. Livika?
Lordship. The
Director General.
respondent number 2 and 3.
Respondent number 2 and 3. 2,
And
3, and
4.
4.
Four also. Two,
Four
three,
also
four.
3.
2, 3, and 4. Take step forthwith for reinstating the petitioner upon a certified copy of the present order be served upon a certified copy of the present order is served upon the respondent number 4. Okay?
Lordship.
Yes,
Respondent number 4. He is the disciplinary, no?
yes, Your Lordship, he has to conduct that.
He's the immediate out there. The
Yes, Your Lordship.
reinstatement. Okay.
Yes, yes.
The said reinstatement, so directed to be made, shall not be later than 15 days from the date such certified copy is submitted to the respondent number 4. With the above, the instant petition stands disposed.
File your Lordship.
Principal seat, timing item 3.
Where is Mr. R.R. Gokul?
I asked him, my lord, he said that the LOI was not given to us.
Your case is similar to that case which I did just now. The you call the disciplinary service case. That case was a case where a person was terminated after holding a disciplinary proceeding in 2019. Matter was going on one day. I was there in Kohima. I heard it. Then I pointed out that how could you have appointed the inquiry officer without allowing him 10 days to submit the what do you call the
Statement.
defense?
Written statement.
So there are no way out because they appointed the inquiry officer directed to file. Means how the concept of having an inquiry officer is foreign in terms with I think rule 9.2 and 9.3. Then I said that okay, go for reinstatement without back wages. They agreed now. Okay. Now where is your case of no LOI? Mr. P.K. Roy Chaudhary.
My lord,
No, your case of no LOI.
My lord, as your lordship will find from page 15, that was provisional.
No, pleaded case, no LOI.
My lord, there is not pleaded case.
I've gone through rules, but this doesn't say about anything of issuing a provisional letter. And 37.3 clearly says a letter of intent holder will have to pay the 15%. The letter of intent holder will have to pay the 15%. He was only issued the provisional one.
The provisional is foreign to the rules.
Yes.
So therefore, he was only informed. We have to consider it that he was only informed that you finally go ahead with go for pay the 10% and all other dues, and thereafter you are to go for all these things.
Yes.
Now tell me, if he was not issued the letter of intent, Can he surrender?
Surrender application can.
Surrender what?
Uh,
What will he surrender? He can surrender a lease. Isn't it?
but to issue, but.
I do one thing. I set aside that document, give him a scope to submit a representation. And they will take a call
That's-
as regards the refund,
No.
other amounts.
No.
You take this point. That if you are question of, well, how will I surrender? Nothing happened.
No.
I just deposited, you did not issue me a letter of intent. And as such, it is your fault.
But he has to even give us an environmental clearance, your lordship, within 45 days. But
Understood. For that, you should have passed an order.
that was not passed because.
You couldn't do it because of the pendency of the petition.
Yes, our hands were tied because of that.
Ah.
There's an interim order because of that. Thereafter, the writ petition got disposed of. Thereafter, he should have submitted the EC to us.
These bench four matters, you have to be very quick. Otherwise, nothing happens. I mean, if you delay these bench four matters somewhere this way or that way,
So let him approach the PCF, your lordship, is better. Let him go to the PCCF. PCCF, he will be a better person to take the call in this.
let him submit a representation in respect to the refund
Refund.
of the amount. And as regard this, we set aside that the question of payment does not arise.
Yeah, as per 37.3.
Heard Mr. P.K. Roy Chaudhary, the learned counsel appearing on behalf of the petitioner. Mr. R.R. Gogoi, the learned standing counsel who appears on behalf of the respondent numbers 1, 2, and 3. The petitioner is aggrieved by the communication dated 5/12/2018, whereby the petitioner was directed to deposit 15% of the bid security amount of rupees 6,15,008 to make up the 25% of the same. To make up the 25% of the security, bid security, in terms with bid security. And further, it was stipulated that why action should not be taken against the petitioner in terms with Rule 37, Roman 5 of the Assam Minor Minerals Concession Rules 2013. Why should I give you the leave? You have not even asked in the writ petition.
His only prayer is to set aside that order, your lordship.
I'll help you.
Taking into consideration, well, he is in a very pathetic state.
So what? First, this ground on which I'm setting us out is not a pleaded ground.
Not a, correct, correct. I admit.
Second, you want some relief which I should give. All these years, 2018, you have not thought about. Not unjust enrichment. The case of the petitioner herein is that the respondent number, where issued the notice inviting tender? He doesn't mention. The respondent number that a public notice was invited for grant of mining rights for grant of a mining contract for award or no, for grant of a mining contract in respect of the mining area Doboka Ordinary Sand Ming, MING. Are you sure?
Mining,
Sand
M-I-N-I-N,
mining,
mining number
number
one.
1 outside RF for a period of 7 years for the annual quantity of 4,000 CUM of sand. The petitioner participated in the said process and was informed by the communication dated 7/1/2014 that a provisional letter of intent was issued to him in respect to the Doboka Ordnance Sand Mining number 1 outside RF for a period of 7 years at the offered annual price of rupees 41 lakhs 50 rupees, 41 lakhs 50 rupees. Subject to following certain conditions. The conditions which were required to be followed as per the said communication dated 7/1/2014 were that the petitioner had to deposit the initial bid security, which is an amount equal to 10% of the annual contract money under the provisions of Rule 37(3) small 1, Roman 1, the small Roman 1, within 7 days in the form of bank draft drawn in a nationalized bank. The petitioner was further required to deposit an additional amount equal to 1 month annual contract money in the year in form of bank draft in a nationalized bank under the provisions of Rule 37. What is this? 37?
P1 probably.
Seven. Where is it required? Seven. He has written 37(1). He doesn't know. To deposit an additional amount equal to 1 month annual contract money in the form of a bank draft drawn on a nationalized bank. Semicolon. The petitioner was further asked to deposit an additional amount equal to 10% of the annual contract money with installments towards the mining and mineral development, restoration and rehabilitation fund within 7 days, etc. It is pertinent to take note of that pursuant to the issuance of the said communication, the petitioner deposited an amount of rupees 11,61,680, which is 10%, which is the 10% initial bid security, comma, 1 month annual contract money, and 10% additional amount Full stop. Thereupon, steps were duly taken for obtaining the environmental clearance as well as for obtaining the mining plan. In the meantime, a writ petition was filed by some persons. A writ petition was filed challenging the contract awarded to the petitioner, challenging the decision to award the contract to the petitioner on the ground that the area where the mining activity was to be carried out was affecting various villages. This court, the said writ petition was registered and numbered as WPC number 3863/2014. And this court, by an order dated 13/8/2014, while issuing notice, directed status quo be maintained in the operation of the Doboka Ordnance Sen Mining number 1 until the next date. The order thereupon continued. The interim order thereupon continued. And it was only on 11/8/2018 that the writ petition being WPC number 3863/2014 was dismissed. The petitioner, on coming to learn, the petitioner was duly informed about the same by the communication dated 30/6/2018 by the respondent number 3. Is he a respondent? Divisional Forest Officer? Yes.
Yes, is a
By the respondent number 3. Pusto. The petitioner submitted a communication on 28/2018 to the respondent number 3, stating inter alia that he would not like to continue with the said contract, would not like to continue, is not interested in the said mining lease on account of he being ailing, he and his son being ailing, and the petitioner facing extreme financial loss in the business. The petitioner also sought for release of the said amount which he had paid. Be that as it may, the respondent authorities, instead of considering the case of the petitioner, issued the impugned communication dated 5/12/2018, whereby the petitioner was directed to deposit a further amount of ₹6,15,008 to make up the deficit 25% of the same. That is 25% of the initial bid security. And further threatened the petitioner as to why action should not be taken in terms with section rule 37(5) of the rules of 2013. Agote Mine and Mineral Rules of 2013. Roman 5D. It is seen that this court, by an order dated, the petitioner being aggrieved by such decision by the impugned communication dated 5/12/2018 has approached this court by filing the present writ petition. It is noticed that this court by an order dated 15/11/2019, my goodness, had issued notice and in the interim, as an interim measure, provided that no action for forfeiture of the amount already deposited by the petitioner pursuant to mining permit in question shall be initiated without the leave of the court. The record reveals that the respondent number 3 has filed an affidavit in opposition, wherein the specific stand taken is that the petitioner was granted the LOI on 17/1/2014 for the mining area. And as per Rule 37(2) of the rules of 2013, the highest bidder shall be required to deposit an amount equal to 25% of the annual dead rent of the contract money as the security, along with an additional amount equal to 1 month's dead rent of the contract money in advance. It was further mentioned that as per the LOI, the Moholder deposited 10% of the initial bid security by letter dated 5/12/2018. It was further mentioned as only 10% of the initial bid security amount was deposited. The letter dated 5/12/2018 was issued to pay the remaining 15%. It is further mentioned that in terms with Rule 37(3) Roman 5, if the letter of holder failed to deposit the balance 15% of the security or fails to execute the contract agreement, the same shall be deemed to have been revoked and the initial 10% bid shall stand forfeited. Pustu. Further to that, it is seen that the respondent number 3 had justified by the affidavit the impugned communication dated 5/12/2018. This court have duly heard the learned counsels appearing on behalf of the parties and have perused the materials on record. In the backdrop of the above, let this court now take note of the respective submissions made by the learned counsels appearing on behalf of the parties. Mr. P.K. Roy Chaudhary, the learned counsel appearing on behalf of the petitioner, submitted that the petitioner herein was never issued the letter of intent, inasmuch as it is only after the deposit of 10% of the initial bid security, the question of issuance of the letter of intent arises. The learned counsel for the petitioner further submitted, drawing the attention to Rule 37(3)(1) Roman 1, two subclauses Roman 1 and Roman 2 of Rule 37(3) of the rules of 2013, and submitted that a perusal of the said clauses would clearly show that after deciding who is entitled to be settled with the tender, the highest bidder, the bidder in question is required to be informed, and an obligation is cast upon the bidder to deposit 10% of the initial bid security. The learned counsel for the petitioner further submitted that after the deposit of the 10%, the respondent authorities, being satisfied, would issue the letter of intent. Referring to clause Roman 3 of Rule 37(3) of the rules of 2013, the learned counsel further submitted that the question of payment of the remaining 15% of the annual amount, 15% of the annual bid amount, what is it? Of the
security of
the
37
annual bid amount
So bid security is equal to 15%.
would only arise when there is an issuance of the letter of intent. He therefore submitted that the impugned communication dated 5/12/2018, by which the respondent authority, the respondent number 3, had directed the petitioner to deposit the remaining 15%, could not have been issued without a letter of intent being issued prior thereto. Per contra, Mr. R. Gogoi, the learned counsel appearing on behalf of the petitioner, respondent, submitted that from the affidavit, from the contents of the affidavit, it appears that the letter of intent was issued on 7/1/2014. And therefore, the petitioner is bound to pay the amount of 15% in terms with subclause 3 of Rule 37(3), and failing which, subclause 5 of Rule 37(3) of the rules of 2013 would be squarely applicable. This court heard the instant matter earlier on 22/7/2025. It is legible over heading Decision and Analysis and Determination. This court heard the matter on 22/7/2025 and inquired with Mr. R. Gogoi, the learned counsel appearing on behalf of the respondents, as to whether the Sanma Hall has been put to sale subsequent to the communication issued by the petitioner on 28/2018 or after the period of completion of the settlement, which falls in the year 2020. Mr. R. Gogoi, the learned counsel appearing on behalf of the petitioner, respondent, submitted, yes, on 5/11.
On 5/11/2018.
5/11/2018, the Sen Mahal in question was allotted to the second highest bidder for a period of 7 years. Analysis and determination. This court have duly perused, heard the learned counsels appearing on behalf of the parties, and have perused the materials on record. This court have also duly taken note of Section Rule 37 of the rules of 2013. In terms with subsection 2, subrule 2 of Rule 37, the highest bidder would be required to deposit an amount equal to 25% of the annual dead rent oblique contract money as security, along with additional amount equal to 1 month's dead rent oblique contract money in advance. However, subrule 3 of Rule 37 stipulates the procedure in which the said amount would be realized. Clauses, subclauses 1, 2, 3, 4, and 5 of Rule 37(3) of the rules of 2013 being relevant is reproduced hereunder. Page 267 of the From a perusal of the above quoted rule, the subclauses of the above quoted subrule, it would be seen that on completion of the bid process, that is the fall of the hammer or the opening of the seal beads, the highest bidder would be required to deposit an amount equal to 10% of the annual bid amount as initial bid security before the expiry of the period allowed. At this stage, this court finds it pertinent to take note of the communication dated 7/1/2014, inasmuch as it is the contention of the petitioner that the said document is not the letter of intent, rather an intimation that the petitioner have been chosen as the highest bidder. On the other hand, the respondents, more particularly the respondent number 3, in his affidavit states that the communication dated 7/1/2014 is the letter of intent. This court further, at this stage, this court further finds it pertinent to take note of subclause 2 of Rule 37(3), which stipulates that upon depositing the initial bid security, stipulates that the initial bid security, so deposited of 15% of 10%, shall be adjusted as part of the bid security on acceptance of the bid by the competent authority, and a letter of intent would be issued in favor of the successful bidder. A perusal of now coming back to the communication dated 7/1/2014, it would be seen that by the said communication, the petitioner herein was asked to deposit 10% of the initial bid security, which is in terms with Rule 37(3) Roman 1. Pustak. And therefore, the said document under no circumstances can be said to be a letter of intent. inasmuch as the letter of intent can, in terms with the rules of 2013, can be issued only after the deposit of the initial bid security. The record further reveals that the initial bid security was submitted on after the communication dated 7/1/2014 and prior to 18/1/2014. There is no records available that there was a letter of intent issued subsequent date. And in fact, it is also not the case of the respondents. There was a letter of intent issued subsequent to 18/1/2014 or after deposit of the initial bid security. This court now finds it pertinent to take note of subclause 3, Roman 3 of Rule 37(3), which obligates the letter of intent holder to deposit the balance amount of the bid, which is equal to 15% of the annual bid amount before expiry of the period allowed. In the instant case, as there is no letter of intent issued, the question of the petitioner in favor of the petitioner, the question of the petitioner being obligated to deposit 15% of the annual bid amount in terms with section Rule 37(3) Roman 3 do not arise. In that view of the matter, it is therefore the opinion of this court that the communication dated 5/12/2018 by which the petitioner herein was directed to deposit the remaining 15% of the bid amount without issuance of a letter of intent is contrary to the rules of 2013 and more particularly to Rule 37 of the said rules of 2013. Accordingly, the instant writ petition stands disposed of with the following observations and directions. Number 1, the impugned communication dated 5/12/2018 is set aside and quashed. Number 2,
Because only his prayer was only this. So setting aside this is an 18 letter.
yes. Accordingly, the instant petition stands disposed of by setting aside the impugned communication dated 5/12/2018.
But as regards my representation, I asked for a return of my money, release of my amount, but they have not considered that one. That my prayer was there in the representation.
Before parting, this court, however, finds it pertinent to observe a submission made by the learned counsel appearing on behalf of the petitioner that the petitioner had requested for refund of the amount which the petitioner had duly paid pursuant to the communication dated 7/1/2014. And as such, the learned counsel submitted that appropriate directions be issued. This court duly takes note of that there is no pleadings to that effect or even any relief sought for. Considering the above, this court is not inclined to issue any directions in that regard. Be that as it may, it shall not be a bar on the part of the petitioner to file appropriate representation before the authorities concerned, and the authorities concerned shall decide the said representation. if so filed as per the parameters of law,
Okay.
without being influenced by the observations made herein above.
These cases are regarding outstanding bill, my lord. I have received one communication, my lord.
What is your stand?
Then, well, I cannot even get that paragraph comment also. My communication is that the record pertaining to these cases had been taken by the vigilant, Chief Minister's vigilance cell, because there was a scam regarding the distillation, and this file had not been returned from the Chief Minister's vigilance cell office.
In vigilance case, your lordship, we got clearance. We got clearance in vigilance case. We got
I have no idea. Document আছে নেকি? Document আছে নেকি?
আজি ৰাতিপুৱা over phone দি দিছে। মই আপোনাক দি দিম এটা কপি।
লগাই দিব ন?
এলেক্সা মানে ৰিচেণ্টলি পাইছোতো। ফাইলিং কৰোঁতে পোৱা নাছিল ন?
So you're entitled to interest also, no? How much?
Interest
No pay.
18?
Your lordship, 18%. Yes, 18%, your lordship.
You can keep it. Keep the file pending. We'll also keep the petition pending. And let it the vigilance have it at the cost of paying interest.
Well, otherwise, well, lots of it directed within 2 months, we'll have examined and paid it, because file is not that, that's the difficulty of that, this stuff.
File an affidavit that you don't have the file.
Lots of it.
And then, and who has the file? So we will ask that authority concerned to pay the interest. If he's entitled to, he has done the work, he has to be paid.
Lordship.
Unless you come up with something that he's not entitled to. Put it on affidavit that he is not entitled to. It is all fake bills.
Yeah.
Then I'll say it will be a disputed question, ask him to relegate him to the civil court. But if you don't come up with all these things, saying that it is in the vigilance.
The Lord's will allow me 2 weeks time, and in the meantime, I will give the entry instruction, even if possible, that file be.
2 weeks time for filing affidavit.
Lord's will.
It's a 2025 matter.
Yes, lordship. But matters.
You are very,
Work was done on
No,
2022, your lordship.
Work was done.
2025 matter, we'll have it in 2026. I'll give you time. Till 2026 December. To file your affidavit. The 22nd December 2026. They are not entitled so early. There are a lot of other people waiting in the queue. Isn't it?
Yes, Lord.
The petitioner herein is aggrieved by the non-payment of the contractual amount of an amount of rupees 1,52,78,515. This court have duly taken note of the work orders which have been issued for hiring of the vehicles, machineries for these siltation of the river channels And there is a specific term in the state work orders that the payments would be made accordingly after submission of the bill along with the logbook duly certified by the concerned engineer with relevant GPS data, if available, in support of the bill claim. And the necessary deduction for taxes, service charge, income tax, etc. will be made at source from the said bill. The record further reveals that after submission of the necessary documents, the petitioner had submitted various reminders. It's also seen that the executive engineer as well as the technical officer of the Guwahati Municipal Corporation have also certified those bills. To the effect that the bills have been duly checked and have been filed with the logbook and found to be correct. The documents enclosed as annexure GHIJ KNH KK. How many are filling? And a GHI are documents provided by the Public Information Officer of the GMC. This court further takes note of that the notice was issued on 24/3/2025. And the respondents were directed to file the affidavit. But no such affidavit has been filed in spite of various opportunities being granted. Today, when the matter is called up, Mr. Esbora, appearing on behalf of the GMC, submits that the files are now lying before the vigilance, CM's vigilance, CM vigilance,
Same.
and as such, they are not in a position to process the same. Per contra, Mr. So-and-so, appearing on behalf of the petitioner, submits that in the said vigilance inquiry, the petitioner have been given a clean sheet.
Yes, Lord.
Under such circumstances, this court fixes the matter on 10th of September 2025. A final opportunity is given to the GMC to file the affidavit by 2nd of September 2025. Liberty given to the petitioner to file reply if so advised.
Item 25.
Same, madam.
25 is the same.
Same, madam. Same person's petition also same. Madam.
Hey, 25 euro order to collect the amount is different.
Amount is not mentioned here, Your Lordship. We sought for post facto work orders, Your Lordship, in this matter.
How much is the total amount?
As amount, Your Lordship, is decided by the respondents. As per rates, etc. is decided by the respondent, Your Lordship. But we sought for in this matter, Your Lordship, we sought for post facto work orders. We had done the work as per the verbal instruction of the respondents.
Verbal instruction?
Your Lordship, we,
No, you can do 25 billion. Apni it is of it to 80 billion. Why are you saying same verbal or work orders and other work orders is different?
This pleading itself is a verbal.
How can there be a verbal work orders? Is it possible?
no, your,
Cannot be, my lord. This cannot be
It
verbal.
cannot be verbal work orders.
Your Lordship, but RTI report is there, Your Lordship. Page number
RTI
23,
is wrong.
page number 23, Your Lordship.
What is there? These are your submissions.
And also, Your Lordship.
How much you are seeking?
Actually, Your Lordship, amount not mentioned here, Your Lordship.
Go to the civil court. You are not clear with your petition. You have to say how much amount you are entitled to. In your petition, if it is not clear, go there. We dismiss your petition, right? Heard Mr. So the learned counsel appearing on behalf of the petitioner, and Mr. S. Gora, the learned counsel appearing on behalf of the respondents. The petitioner herein is aggrieved by the inaction on the part of the respondent authorities in not making payment of the bills to the petitioner. Not payment of the bill dated 22/3/2022. For the services provided by the petitioner. For the period from 1/7/2021 to 31/7/2021. It is further seen from the records that the petitioner claimed that these work orders, that the petitioner were asked to carry out certain work verbally by the who?
In paragraph 5, my lord, page number 5, he says that by respondent number 2 and 3.
By the respondent number 2 and 3. And the petitioner duly performed their work. However, the payments have not been made. The materials on record do not show what the petitioner claims and as to whether there was any recognition as to any admission that the petitioner have carried out any work, save and except certain documents provided to the petitioner under the Right to Information Act. This court have duly heard the learned counsels appearing on behalf of the parties and have also perused the materials on record and do not find that this is a fit case for exercise of jurisdiction under Article 2 to 6 of the Constitution in absence of any work orders being issued to the petitioner. And the petitioner having done the work and such work being recognized by the respondent authorities. Consequently, this court is not inclined to entertain the instant writ petition. Accordingly, the writ petition stands dismissed. Be that as it may, this court, however, observes that the petitioner herein, if so advised, would be at liberty to file appropriate civil court, approach the appropriate civil court, seeking realization of amounts from the respondent authorities, and the filing of the instant with petition shall be the deemed notice to the respondents if the petitioner files a suit seeking realization of recovery of money. So the period during which the instant petition has been pending, that is from 25/3/2025 till date, be excluded while computing the period of limitation.
For orders item 7 to 13.
Yes, what are these?
Lordship, few of the orders, 7, given the numbers which have been.
What is contempt cases?
Yes, some of them can be closed, Lordship, because they have passed the speaking order. And
We take the writ petition, na?
we take the.
Which is that?
8, 9, and 10 can be clear.
Item 8, 9, and 10 can be closed.
So, Mr. Bottago, you are ready?
So we can start with the writ, Lordship.
A lot of files with you. I think it's high time to finish it, these all. 2019, 5 years have gone by.
Because these they passed in item number.
These are all contempt matters. We consider which one?
The Lordship, the writ. Item
WPC kon diokso.
WPC.
These are contempt cases.
WC 4631.
4631, Lordship. Item number?
Item number 11.
Item number 11, 4631.
Yes, got it. Garg Poly Industries.
Yes. Lordship, the petitioner is a SSI unit duly registered under the MSME Act. Lordship, the MSME registration is at Annexure 4. Annexure 4, Lordship, page 57. And Lordship, we also have an enrollment certificate issued by the ASIDC.
The principal amount, have you got it?
Principal amount we have got after your Lordship's order.
Okay, now only remains
The interest part.
and setting aside the speaking order.
Setting aside the speaking order.
Let's see the speaking order. What is it?
Lordship, the speaking order is at
287.
page 287. Two 88 is also relevant.
You have got the 62 lakhs?
Yes, we've got the 62 lakhs. After your lordship's order, we have got the 62 lakhs, finally. Now, this lordship order, the chief engineer.
So the question is, in view of their basic idea, is in view of the, as you have been paid the 62 lakhs or 40 lakhs, whatever it may be, in view of the memorandum of understanding remaining
Yes.
in existence from dated 14/5/2019, the question of further interest beyond
31 1919, this is in respect of the NRWPP fund, lordship. And there are two funds, one is the state and one is the national fund. This memorandum is in respect of the national fund, not the state fund. So state fund, that's a 62 lakhs which we got pursuant to your lordship's order. This was clear to us. Now
that had an interest element.
That even this also has an interest element, but the interest element up to 2009, 31st/3/2019, despite the undertaking, has not been cleared. Interest has not been touched.
No. The amount which you are actually entitled to, how much as per the contract?
As per contract, lordship, there are different bills. They have admitted, there's admission, I will pass your lordship, because in this case, not a single amount has been paid, which is the admission. Expenditure 16, page 153. That is the amount calculated by the department. 153.
Additional. Yeah.
The lordship 159 is a chart which the respondents have provided. Here they say principal amount, total.
Where do I find it?
Page 159.
$44 lakh.
This is?
And principal interest, principal amount, total fund paid, 44 lakh. And state, this is NERD.
Yes.
State fund is balance is 62 lakh.
Yes.
And to be paid is along with interest of so and so. So your case is the memorandum of understanding is only in respect to the NRDWP.
Yes.
Not for the purpose of the state.
No.
And as such, on the basis of that memorandum of understanding, they cannot deny you the interest.
In the state fund also. And even under NRWP, there is a commitment in the memorandum that they will pay. In fact, they had almost told us that you take interest up to 31st March 1919, and beyond that, we will not pay you any interest. And then you sign this. We will give you this much. Lordship will take a look at the memorandum. I will. One page 109. Page 109.
109.
This is the memorandum of understanding, whereas the government has agreed. Lordship, this in memorandum of understanding made on this day, 14 March May 2009, between GARG, incorporated under the Micro, Small and Medium Enterprise Development, this, having registration officer this, whereas the government has agreed to pay the company some due under the terms of the agreement. Final principal amount under the NRDWP heading rupees 42 lakhs 54,000 etc. is due for payment as on 14/5/2019 under the head of this. Further an amount as calculated up to 31st March 2019 is payable by the department towards interest to the company firm. Now, the memorandum hereby agrees to pay the entire principal amount of this due in a one-time payment. But both the parties considering the payment of the principal amount above is agreed to full settlement of the principal amount due under the head this, agreeable upon not claiming any interest under this beyond 31st March 2019, which means up to 21st March 2019, they are liable to give us the interest. They have undertaken to give.
This is only for 44.
Only 44. But as far as the state plan, the 62 lakhs is concerned, there's no such understanding. But that own admission, they have given us a calculation. We have not calculated the amount, they have calculated.
Now you are asking for that 62 lakhs the interest.
6 crores, I think 62 lakhs. And it has come up to that.
That 62 lakhs was also admitted later. That is also paid. That is the
That we have
principal.
admitted.
Yes. And 42 was paid back in 2019 itself. Now what remains is they are claiming interest under the MSME Act. That is what they are claiming further to what has been already paid.
Now tell me, this was in respect to a contract?
Contract.
You have the contract here?
Yes, Lordship, I have the work order. It's a work order, Lordship.
67.
It starts page 67 onwards. I have in next. Page 67. These are the contracts I've in the work orders, Lordship. Because this is a very peculiar system. The price is fixed. We do not quote a price, Lordship. The price is fixed.
57 is a this for manufacturing enterprise as well. 57 is that?
67, Lordship, 67.
67. Okay, this is the contract.
This is the work order.
Supply
order.
UPVC.
Supply the following UPVC specification.
So it is only this contract or any other contract?
To a bunch of work orders.
Oh.
Page 670, page 70, and then up to page 90. These are the bunch of work orders which are issued to us. We are supposed to supply these pipes to various places. The places are also given, like Nagaon, Tejpur, etc., etc. They gradually we are supposed to pass.
Now tell me.
Yes, Lord.
As regards these contracts.
Yes.
Whether there is any requirement that have you mentioned about that you are a MSME at the time of entering into the contract?
Yes, Lordship, because what has happened, the policy of the government, initially it was under the Assam's Preferential Storage Purchase Act. There were some listed items, scheduled items, which the government departments are mandated to buy only from SSI units. And that was under the APSCP Act. After the APSP Act came the MSME Act. And under the MSME Act, the government of Assam had this policy, the procurement policy, preferential procurement policy. Under that policy also, what is the motto of the policy is to promote local small-scale industries, and these items are mandated to be purchased only from the small-scale industries. And these, the price.
Where is that?
Annexure 1 and 2, Lordship. Annexure 2.
Differential is one, procurement policy. 45.
Page 45.
This is of the year 2015 only.
Yes, after the MSME Act came into force, Lordship, and we are supposed to have a policy.
But these work orders were prior to that?
No,
Yes, come to 67?
Lordship, this came, this is 15, Lordship, 15 work orders, 11, 15, 10, 55, 10. This is after the MSME Act.
Huh?
This is at 15 after the MSME Act. This
Understood, but whether MSME, this was any, have you put them to notice about the MSME Act thing?
Lordship, they were they were acting under the MSME Act because this procurement policy was.
MSME Act, this policy only came, preference policy in 2015.
Right, correct, Lordship. Before that.
Before it came sometime after or prior or after immediate.
Before that, we were governed by the APSP Act, Assam Preferential Stores Purchase Act.
This is a policy only.
Yes, before that we were, it is made under section 18, no? No, it is made under the provisions of the MSME Act.
Let's see the MSME Act. Does it say that you have to pay? First of all, without notice,
My lord,
how can I interest of such a?
Lordship,
one more aspect, my lord, if I may point out. Page 295 is the Udyam certificate, MSME certificate. The date of registration, my lord, 3/5/2023.
no, Uddum will come later. Before that, we have EM Part 2.
295. my lord.
We have EM Part 2. Now we have Uddum. EM Part 2 that is what you need under the MSME Act.
295.
Which under which provisions is made here? Procurement policy that.
The procurement.
At the bottom, my lord, will see date of Udyam registration.
Because that time Uddum was not there. Please check the facts.
Classification date small on 30/5/2023. Prior to that, they must be having.
I have MSME Part 2. I have my SSI unit registration. I have the enrollment certificate. Uddum
Where is your registration certificate in terms with the MSME?
Lordship, I'll just point out, Lordship, it's at NHF 4, Lordship.
Page 57.
Page 57. Lordship, this came after the Aadhaar. Uddum came after Aadhaar. So this time, page 57. Guard University has filed a memorandum for this. Item this indicated below.
This is a small scale.
This is, Lordship, under the MSME Act, Part A and Part 2. NHF 4. EM Part 2.
Where does it say that it is registered under the MSME?
Lordship, this is the certificate which you passed, and it is signed by the General Manager, Districts Industrious Commerce Center.
As a small SSI unit?
Yes, Lordship, that is what we are.
So SSI unit, does it become automatically MSME?
Yes, Lordship.
Let's see from the act.
The memorandum.
This is filed under Section 8 of this. SSI unit is a small unit which falls under the MSME.
Let's be.
If Lordship looks at Section 7 of small industries, classification of enterprises, Section 7 of the MSME Act.
Section 7.
Yes, Lordship.
7 only.
Yes, Lordship. A micro enterprise, A Roman 1, a micro enterprise when the investment in plant and machinery does not exceed 25 lakhs. A small enterprise where the investment in plant and machinery is more than 25 lakhs, but does not exceed 5 crore. And a medium industry is which has an investment in plant and machinery, which is more than 5 crores, but does not exceed 10 crores.
But, madam, have you just, I mean,
Yes, Lordship.
but madam, tell me one thing.
Yes, Lordship.
Why I'm saying, when you come to section 8,
Yes, Lordship.
any person who intends to establish
Yes, Lordship.
a micro, this is okay, B medium is okay, medium enterprise, okay.
Yes.
Shall file memorandum of micro, small, or as the case may be of the medium enterprise with such authority as may be specified by the state government under subsection 4 or the central government under subsection 3.
Yes.
Provided that any person who before the commencement of this act established a small scale industry, that is you,
Yes.
and obtained the registration certificate may at his discretion, others is not, and an industry engaged in the manufacture and production of so and so, shall within 180 days from the commencement of this act, file the memorandum in accordance with the provisions of this act.
Yes.
Now, have you done that?
We have done that.
Where is that?
My memorandum is that, Lordship, at Annexure 4.
Next, sir.
Annexure 4.
This is not there. This is only an SSI registration.
No, oh,
But
sorry,
as
Lord.
you submitted the
Sorry, I'll just show you, Lordship.
Now, Madam Gali, come to another one.
Yes.
Important notification relating to Micro Small Industry Development Act 2006, and more particularly the memorandum, how it is to be filed.
Yes.
In terms with this memorandum has been issued in a year with effect from so and so. Or this is for Udhayan in 2020.
Yes.
So this is for recently it has to be done, how it is to be done.
Yes.
Who intends to establish a micro healthcare on registration of an e-certificate shall be given. Composite, what happens to the earlier person? Calculation of investment in plants. This is for, has come in 2020. This particular notification which has been exercised under section 7(9). 7(9). Notwithstanding anything contained in enforcement, while classifying any class of the very but Mr. Botta could tell me, as per this, how do you register? Because section 8 categorically mentions that if you are a small scale industry, which the petitioner is, there's no quarrel with that, is required to submit a memorandum. And what happens thereafter?
Whether a certificate with MSME name is separately issued or whether the original registration is continued.
This is a very important thing because you see, even an SSI unit is required to submit a memorandum to come within the ambit of this act. She is entitled to interest only on the basis of this act.
Yes.
So as on that day, because your various dates are sometime in the year 2014 and sometime in the year 2015. As on 2015, whether there was any of these type of memorandums or registration under the MSME Act. Now in 2020, they have come up with this particular notification under 7(9) and say that now you have to register. And this notification, which is given recently in 2020, I think that is the fallout why you have that document that you have enclosed in 2023. 2023 document, it seems to be a fallout of the 2020 notification.
Yes, Lordship. Only then the registration became necessary.
So
Lordship.
therefore, there is a requirement somehow, somewhere, that there is a requirement of a registration.
Lordship, I have put the registration, the respective registration and the work orders at page 13 of my petition.
Page?
Page 13 of my petition.
Your petition?
Yes, Lordship. Read petition. At paragraph 18, Lordship.
Time of issuance of the work order, and so.
These are the respective EM partners.
Now you are claiming to be registered in terms with page 57.
Lordship?
See, you are claiming to be registered as MSME as
Yes.
per page 7.
That is what I have to file, and that is the registration. There's no other certificate of registration given.
No, but
this is only
whereas Garg has filed a memorandum for manufacturing enterprise as so and so for the item indicated below, and activities have commenced from Iman as stated in the form allocated to the enterprise memorandum number so and so, date so and so, manufacturing so and so. This we are UPBC pipe so and so. This we are. The issue of acknowledgement does not restore any legal right. The enterprise required to seek clearance license permit required under the statutory stipulation in case of any change in the information of so and so.
And Lordship will see there is a MSME inspection report also.
Where?
At page 61, with reference, I have forwarded you a duly signed report at page 61.
This seems to be In my opinion, this seems to be SSI registration
No, Lordship,
for the
it's,
purpose of getting the benefits on some schemes.
no, this is one, this is the inspection, but as far as MSME is concerned, Lordship will find section 8 talks about the applicant will file the memorandum, which will be duly signed by the Lordship will find what we are supposed to do is that Lordship, where any person who intends to test up this, and the other shall file a memorandum. That memorandum has to be filed by me.
File the memorandum of,
Memorandum of
as the
small
case may be of medium interest.
With such as may be
authority as may be specified by
by
the
the
state
state
government
government.
under subsection 4 or the central government under subsection 3.
Here the section,
May shall by notification specify the authority with which a micro AM may file the memorandum.
yes.
We have this anything to the effect.
But this, I don't have the notification. I can always look for the notification. So my EM part 2 was filed by me before and was duly countersigned by the general manager, district industry center, because I am a small scale industry and I come under the general manager, district industry center.
Madam, all my formidable years as a lawyer, when I was doing a lot of subsidy matters, I could see whenever an SSI unit or anybody, because if you see the industrial policy of Assam in 1997, then in 2003,
yes, Lordship.
There are certain impetus being given to the small scale industry.
Absolutely.
For that, you need to be registered under the general manager of industries and all.
Absolutely.
So first you register yourself and then you have to apply.
Yes.
The document which succeeds page 57
yes.
is an EM report.
Yes.
EM part 2.
Yes.
EM part 2, if you see the 1997 industrial policy of the central government, you find this EM part 2 which is to be filled up. This is how the things work. But the only question is
yes.
whether this is the only document, because here it is only said to be a memorandum as an SSI.
This is something which I have to file. That this general manager had
Because
to
this
endorse.
is issuance of an EM part 2. EM part 2, in my opinion, cannot be considered to be a certificate to the effect that you are under the MSc.
No, it is a MSc. I have to file that, but I have to be a small scale industry. So I have a certificate.
We'll do one thing, we'll give you some opportunity. We'll hear you again. This is the issue where it is. The issue is very small. First of all, whether you are an MSME is on the date on which you were allotted the order. If you were there and you were only issued the orders because if you were an MSME, you had the knowledge that MSME Act applies and Rule 80, Section 18 applies. It's the issue, long and short.
Section 17,
Then-
16 applies.
But the question is whether you are an MSME.
Yes.
The MSME requires, as per Section 8, that there has to be a filing of a memorandum.
Yes.
And it has to be before the authority, if it is the state government, in terms with sections 4, subsection 4 of Section 8, or if it is the central government under subsection 5 of Section 8. Now, I was looking into as to whether there is any rules to that effect.
No rules.
The micro small furnishing of information rules 2016, then micro small industries fund rules, industries on delayed payment rules, so and so authority. Now there are memorandums which have been issued in the year 2020 whereby the Udhyam registration aspect comes in. But how that also mandates that there is a requirement of a registration. Now, where is the registration under the MSME Act? That is the question. I hope Mr. Bottas,
Register.
Yes, I've
you
understood
have
your
to pinpoint your argument on that.
And Lordship, I'll show.
Because then what can, if madam is able to show me, then I will give a declaration to the effect that she is entitled. How much?
Let him calculate. Let them calculate, Lordship.
But first of all, I have to be satisfied.
Okay, Lordship, I'll show
So
them.
I have pinpointed the issue, the big five. And those contempt matters no longer survive.
Except APP, they have not passed this order there. 7, 8, 9, and 10 don't survive, right?
No, you have got all your money. The only thing you
yes,
have not got out here is the interest. That is your only contention. Then what remains in the?
Lordship, they can
Close this.
They can close.
Unnecessary. Allowing
Records become
Mr. Aibot Thakur again to represent those respondents.
But I will have to, Lordship, rely on some affidavit. But I have an Excel.
It will be kept on record.
I have an
The
Excel.
records will be there. But the issue is this. I don't need any other records for that. The issue is very pinpointed. The moment he comes under this, so therefore the issue it comes under an MSME, and there is a requirement only to be issued to MSME. Because I remember the industrial policy of 97, 2003 of the SAM, as well as another one which came up in 2011.
Yes, Lordship.
These state that it has to be given to the SSI unit, whereas the central government's units did not have those. You see the 97 industrial policy or the 2007 policy, they do not have those SSI unit aspect. But the state was giving impetus to the state, the small scale industry.
We had right from 1997. No, before that, Lordship. Because I remember doing those things as a junior.
83 was the first one.
83 was the first one. Because I did Lordship when I was attached to my senior then. That is how I got to know about the industrial policy.
83 was the first of these industrial policies which came.
Lordship was also.
The last time, in fact, yesterday I was looking into, I remembered I was taking up Dr. Todi's matter. The matter pertains to not granting of captive subsidy on the generating unit.
Captive consumption.
Yes, that is captive consumption thing. That is an industrial policy of 2003. I just asked him a question is, how is it possible that we are in 2025, we have not received anything?
Lordship, I'll also show everything how EM Part 2 is.
If you necessary, you file an affidavit. If necessary, you bring on record by way of an affidavit. If you don't have those documents here.
Because these documents we have all, I'll give all my registrations seriatim in by way of.
No, whether there has been a filing of a memorandum in terms of Section 8.
Correct.
Is it before the appropriate authority as per the notification by the central government, by the state?
But state government.
If it is so, then it will be there. Then in respect to those contracts which have been awarded, is it only required to be awarded to the MSME? This is a very important issue.
That is correct, Lordship. Some government policies are there. The policies are there, procurement policy, APS.
Well, the procurement policy is there in 2015.
Yes.
Prior to that, whether there was a procurement policy.
Lordship, some preferential stores purchase.
So does it say about only SSI?
That talks about SSI.
So SSI is a different aspect.
No, SSI.
Then do you come within the ambit of that other one, the interest on delayed payment?
Lordship, that what happened? If I just before it was some preferential stores purchase. Then Lordship, initially there was, that is I think 1983 Act or 89 Act. And then initially there was nothing for small interest. Then came the interest on delayed payment tax. Then they took care of the small scale industries to a certain extent. After that, delayed payment was repealed and MSME Act came into force. So MSME Act came into force for these industries. And Lordship, there, if I may point out, but I may place on record later, there's the decision of the Supreme Court is that all you need to be a SSI to be entitled to this interest. When the MSME came in, it became we were issued we had to file the EM Part 2. That was only the filing we had to do before the authority were notified by the state government. And then the procurement.
I think there will be some notification to the effect.
Maybe.
There has to be some notification. Because when Rule 8 says, because you see, Section 8 makes a very clear aspect. In normal circumstances, if you want to have a mini, micro, in the micro, small and medium industry, you can file your memorandum at any point of time. There is no quarrel. But if you are an SSI unit, you are required to file within 120 days.
And
yes.
Before the authority, meaning thereby there is a requirement of some procedure. How the registration happens
I'll
is
just
the
place that.
aspect which needs to be.
I'll place that.
Prior to this 2022 or 20 notification, there has to be some other
There is
notification.
another.
Find it out by the
Yes.
state or the central government.
Lordship may fix a date.
Mrs. M. Hazarika, the Learned Senior Counsel, assisted by Mr. D. Khan, appears on behalf of the petitioner in the writ petition being WPC number 4631/2023. The Learned Senior Counsel, appearing on behalf of the petitioner, submits that though, along with the writ petition, there are various contempt proceedings attached, tagged, but taking into account the scope of the writ petition, which is only limited to as to whether the petitioner at present would be entitled to interest in terms with the Micro, Small, Medium Enterprise Development Act 2006 and more particularly Section 18.
Not 18, interest is under section 16.
Huh?
Section 16.
Interest is under
Section 16. 15 and 16.
Interest under 15.
In liability comes under 15, interest comes under 16.
16.
Yes.
Interest, Section 16, comma. The contempt proceeding filed may be dropped, taking into account the substantial compliance however, without prejudice to the rights of the petitioner in the writ petition. This court, while hearing the matter, inquired with the Learned Senior Counsel as to whether the petitioner herein is registered under the Micro, Small, Medium Enterprise Development Act 2006, for short, the Act of 2006. And in that regard, the Learned Senior Counsel drew the attention of this court to Annexure 4 to the writ petition and submitted that the issuance, certificate of issuance, bracket EM, part 2, amounts to registration under the Act of 2006. This court further, while taking into account Section 8 of the Act of 2006, and more particularly the requirements stipulated therein of filing a memorandum by the filing a memorandum for registration under the Act of 2006, inquired as to whether such memorandum was filed, more particularly taking into account that the petitioner herein was a small-scale industry set up in the year 2014. The Learned Counsel submits and if so, before which authority? The Learned Counsel submits that there are various notifications issued by the state of Assam. And she would further like to placed before the court, the manner in which the registration, the manner in which the memorandum is required to be filed by the SSI unit so that they come within the ambit of the Act of 2006. This court also heard Mr. Ibo Thakur, the learned counsel appearing on behalf of the PHE. Who submitted that the petitioner's registration as an MSME under the Act of 2006 is only in the year 2023. However, Mrs. Hazarika, the learned counsel, senior counsel submitted that this is a fresh registration done in view of the requirement in terms with the criteria for classification of micro, small, medium enterprise and form and procedure for filing memorandum bracket Udyam registration as amended. Udyam registration, as well as the notification issued by the central government to Udyam registration certificate. Taking into account that the matter had been substantially heard and there would be further hearing required in view of the submissions so made by the learned counsels appearing on behalf of the parties, this court fixes this matter again on 9/16, which would be convenient to you.
9 September.
9th of September 2025. Not only. This court further taking into account the submissions so made by the learned senior counsel that there has been substantial compliance to the orders so passed, drops the contempt proceedings, being contempt proceeding number, contempt cases numbers, a number with the Jimoha 7, 8, 9, 10. 7, 8, 9, 10. Drops the year. However, without prejudice to the petitioner, rights in WPC number 4631/2020. There are 3 petitions.
Absolutely, yes, Lord.
Huh?
All are same.
These are all different petitioners, na?
Different petitioners.
Of the petitioners in WPC number 4631/2023, WPC number 5273/2023, and WPC number 5966/2023. Full stop. This court, however, directs the registry to keep the records of the said contempt proceedings tagged along with the instant proceedings, taking into account that there are various pleadings which have a material bearing to the present proceedings, to the writ petitions. Yes, what are you waiting for, Mr. Suman Chakraborty?
For hearing item 14.
Number 18. I'm for the writ petition is against an award where the workman's nomination was held.
Oh, that one.
No, it's a
Orjan.
No, my lord. It is an ambulance driver.
Appears on behalf of the. You're the petitioner.
No, item number 18. I'm for item number 18.
What is this item?
Item 13.
Workman of Borazan Estate?
I'm not.
I'm there.
Oh, yes. Tell me.
Lordship, we are against the order of the learned labor court. Agreed by that, so. Deplore.
Mr. Ethakur is not there.
He's there. He had a surgery recently, so he was a little feeling well, so he's there only. But he
Okay,
said,
we'll have it
if you
after
permit,
vacation.
I'll do it. Lordship.
After vacation.
Lordship.
Any urgency of any of the matters? Take a date, ask for a date. Yes, Mr. Doctor, what are you waiting? On a Tuesday afternoon,
Item 16 and 17.
16 and 17. United Presiding Officer, Labor Court, Management. Same matter.
No, these are two different matters.
There are many labor court matters, huh?
Yes.
When do you want? You want to do it?
Any day convenient to your lordship.
I'm not, there's no convenience for this court, taking into account there are so many matters. here. You have these tender matters, all have urgency.
Yes, yes. But your lordships has the tremendous patience, my lord. Even at this hour, your lordship is looking very fresh.
But the thing is, what is required is this content. This labor court matters needs to be finished.
Yes.
These are old matters.
Right.
I will do one thing. Now I'm having a lesser pressure in the High Court bench, in the High Court bench. Most of the contentious matters have been disposed of, na? So now I will be asking them to give me these labor court matters and fix a day in a week to finish up these as soon as possible. Well, the labor court matters, keeping them for long, people also lose a lot of faith, and even the industrial dispute which is there lose its efficacy.
Yes.
I'll have a word with the Chief Justice on this. Finish it off on Thursday.
My lord,
Thursday.
only your lordship excuse me on 11th August, I'll be otherwise.
No, not now. I'll have to make out a list. It has to be done. Because the labor code matters can't remain for a long time. It has to be finished off. But you don't get the time otherwise. Okay. If you need any, take a date, because I won't be here from 25th to 5th. I'm not here. I'll be sitting, holding the roster out there in Kohima. So thereafter you are coming, the vacations are nearing by.
Your lordship is going to Kohima when? Kohima? 25th.
I'm going on 25th. They are sitting in 25th. So I'm from 25th to 5th. I'm not here in the principal seat. So therefore, there immediately thereafter you have the vacations nearing.
Yes, yes.
But I think I'll do one thing. Wait, let these matters be there in the list. Means they will give a date if you want.
Right.
In the meantime, I will. This may be shown as leftovers.
Well,
I will take it up with the registry and schedule
all
it
right.
out. And all these labor court matters, please.
Yes.
3-4 Thursdays, I think, would be enough.
Yeah.
Yes.
Item number 18, can it be on 21st? Item number 18 is also a labor court matter. Is the workman who is before your lordship. Item number 18. Can it be on 21st of this month? Is a hearing day, my lord. It's a Thursday, I suppose.
What is this matter?
Well, it's an award termination. No inquiry was held, terminated. Without domestic inquiry terminated, before the labor court also, they have relied on certain documents without examining those persons. In spite of that, labor court has awarded against the workman upholding the dismissal.
Yes.
My lord,
No.
I'm appearing in item number 16.
Who is appearing for 18? Is there?
Appearing for 18, first
Yes.
call number 2.
When do you want it?
Your lordship, I'm fine with 21st of August.
Hello? 21st, 2 p.m.
Madam.
We finish. Mr. Doctor, you don't have any urgency in your matter.
That way, I don't have any urgency, but my learned friend is having.
Yeah, which item?
16, my lord.
16, so far 16 is.
This is United Bank of India versus presiding officer. There's a stay.
Yes.
Stay as regard retransfer, this is for dismissal.
No, it's not a case of dismissal. My lord, the award is that the bank should comply, restore the order. One circular is there. Those who are canteen boys, they are required to get their job in one-time settlement, as one-time settlement. That
has
was,
stayed.
yes,
Ah,
he was not found to be fit, and that's the reason he could not be given that.
you have difficulty on 21st.
21st.
Brihaspatibar.
21st is okay, my lord.
21st, top of the list.
Okay.
16, huh?
Yes.
Yes, Mr. Datta. You don't feel like doing matters, now you are asking, seeking an adjournment.
I think 50 on last occasion also the management council was not appeared today also, and they have not paid 17B amount to me since January 2025. And also area amount was not paid from the date of award till 2019. Award was 2015.
Today also they are not there.
Not.
Okay, none appears on behalf of the petitioner on call. Mr. PP Doctor appears on behalf of the respondent number 1. Oma. List this matter again on 12 of August 2025 at 2 p.m. Taking into account the urgency shown by Mr. PP Doctor, the learned counsel. It is observed that in the circumstance, the petitioner is not represented, the court shall dismiss the instance petition for non-prosecution.